ಮ್ಯಾರೇಜ್ ಲೈಫ್ ಅಲ್ಲಿ ತುಂಬಾ ದೊಡ್ಡ ರಹಸ್ಯ ನೀವು ನಿಮ್ಮ ಮನಸ್ಸಲ್ಲಿ ಮುಚ್ಚಿಟ್ಕೊಂಡಿದ್ದೀರಾ. ಕಾಲ್
Yes.
Hello, it's a fresh matter. It's a PIL matter. We are seeking direction for release of amounts which is held up in the Urban Development Department for development of constituency, Dasarali constituency.
29 July.
Please.
I have serial number 20, my lord. I have moved on, my lord says directed.
So all, Madam,
5th July.
Subject to removal of, Madam, just subject to removal of office objects.
Please, my lord.
Provided you have removed the office objects.
We have complied, my lords.
Serial number 20, my lord. I have moved on, my lord says directed to post on 5th July. I have engaged the service of senior advocate from Delhi. He requested on 5th July, my lord,
30th.
along with connected matter, writ appeal, my lord.
30th July, yes, yes.
Your lordship.
5th July, my lord.
July.
My lord, directed this matter to be listed on 5th, my lord. I have briefed and booked the tickets, my lord, for 8 tickets on 5th July, my lord. I request, my lord, on 5th
Which
July.
is the subject? What is the subject?
My lord, this is the central government, my lord, black pepper matter, my lord. That is customs department has been, my lord. Therefore, 5th connected matter is listed on 5th July, my lord. 9:47 of 24 on the same day, my lord. So, therefore, I request, my lord, this matter is also same, my lord, same connected matter. I'm sorry, my lord, troubling my lords, my lord.
5th is not possible. You take any other subsequent date. It's too near, not possible to take up. It can go to 19th of June.
My lord, because urgency, this, my lord, my black
So-
paper, my lord, consignment, my lord, is de-stuffed.
5th is not possible, is not. Today it is kept, but today not convenient to you, no difficulty. Another date, but not 5th.
Your lordship.
My lord, then, my lord, I request, I will take chance on 5th, my lord, because connected matter is there.
5th August.
Your
Yes.
lordship.
My-
Fresh
sorry,
writ.
So we are telling 19th of,
My lord.
not possible is not possible, mister. We have a lot of matters on the board and we can't go on shifting the matter at your choice.
I will
That
take
is
my
equally
chance.
true.
I will take my chance, man.
No, 5th is not possible. 5th is not possible. 19th you come, yes.
Your lordship. Two fresh writ appeals. Senior counsel, Mr. Mr. Uday Holla is being.
Pardon?
Senior counsel, Mr. Uday Holla is mentioning a matter.
Lord, I'm sorry, my lord, I was stuck
Yes.
in a traffic jam. I could just come to the office, my lord. Couldn't come to the
matter.
court. My lord, there's one matter, my lord, where in respect of shares, my lord, yesterday, my lord, the judgment has been delivered and the writ petition has been allowed. Against that, we have filed a writ appeal, my lord. Urgency is, my lord, they'll issue the shares and then there has been, my lord, wholesale fraud by a company called Byju's, my lord. And if they issue the shares and they have been misappropriating funds. So can I request your lord just have it at 2:30 or tomorrow, my lord?
We have served the copy.
We have served the copy on the other side also.
Day after.
My lord, if it is possible tomorrow, my lord, I'll be grateful. Otherwise, my lord, I'll take your chance, my lord.
Tomorrow we have bench. Tomorrow, all right.
Grateful to your
Tomorrow.
lordship.
Tomorrow.
Grateful, my lord. Grateful.
Doesn't matter. There you go.
Second time for the content petition filed again that will for disobedience. This order, this report ordered, if the matter is not complied with, the complaint is at liberty to revive the content. So I request you not to find a.
It will be listed in due course. Remove the, comply with the office of.
The office objections are complied.
Then very good. There is no question of mentioning them.
Because
we
the
list it.
report, there's a specific direction that it can be.
All
revived.
matters, once the office objections are complied with, are being listed within week. And all mentioning which are not listed since filings in March and January and December are all wrong because I have personally verified why it is not listed. You don't remove the office objections and come here with a memo that I have filed it in December, March, February, but not listed. But you, if you have removed, very good.
No,
We
the
list it.
contempt petition was disposed of
We understand you want to revive the contempt petition.
for revival after 6.
Correct. It will be listed. Yes, Mr. Pardon? Which one? Little louder. Mic is there. No. Without urgency, no such name.
The lordship's kindly. I appeal for the respondent minutes in a writ appeal. Minutes stay is granted, reserving liberty minutes to file a vacating application. I have filed the vacating application. The matter was listed last minutes on 23/20/2023. Minutes because of the stay granted minutes, the contempt that is filed by me minutes is not being considered. I would request your lordship minutes to consider the vacating application that is filed by me.
IA is there,
IA is there.
18th July.
That's one matter for tomorrow, my end of the list, madam, because the tomorrow is announcing the result, madam. It's a cooperative matter. Initially, we preferred a writ petition, that was allowed. The respondent number's executive officer has filed a review petition. The review petition allowed and our is not kept. They're not counting our votes, madam. That is the reason, madam. If it is tomorrow is not
Election is
today.
counting is tomorrow.
Yes, madam.
Counting is tomorrow.
Please.
Why you are coming at the last moment?
They don't. That's
Why
one
you are
thing is
coming on the
petitioners.
previous day?
Petitioners have in the last moment they have.
It is a writ appeal.
Please.
So when learner single decided it?
No, review petition, my lord, on it was disposed on this
When it was disposed of?
14/6,
14th of?
this month,
Then
last month.
15 days.
Otherwise, my appeal is becoming infructuous, madam.
Then why your last moment?
They are assigned only yesterday, my lord.
It is review petition.
No, this is
Appeal.
appeal.
That is
Appeal.
what we are asking, appeal.
Please, my lord.
So when did you file it?
My lord, day before yesterday, my lord.
All like to know.
Serial number,
Subject to the, subject to removal of officer. If any office objection is there, Mr. Court officer, if any office objection is there, don't circulate. Even minor office objection not to be circulated, yes.
Lord, serial number 44.
serial number 8.
We will not break the line, yes.
See, item 44, my lords, counsel for the petitioner is unwell, he's down with fever. He's requested for 2 weeks, my lords, 44.
40
Please.
is regarding what, contempt.
Please,
So what do you want?
my lords, he's not well, the counsel is not well, he's requested for 2 weeks' time.
Week's time. 11.
Please, ma'am.
Lords, kind leave, my lords.
Serial
May-
number 8, my lord. My senior counsel, I'm appearing for the appellant. My senior counsel has not recovered from open heart surgery. So kindly grant some time,
When do you want?
2 weeks from now.
Request of learned advocate Mr. Srinivas KN, send over to 5th of August.
Lords, may I make a mention for serial number 62, my lords?
62, yes.
I appear for the complainant, my lords. I have filed an IA for impleading. There are some office objections, my lords, which I'll rectify. 2 weeks may be granted, my lords.
7th of August. At the request of learned advocate for the complainant, send over to 7th August.
Pledged, my lords.
My lord, in service matter, a writ petition was filed, my lord. The single bench, honorable single bench judge was of the opinion that the matter may be referred to the division bench because the writ appeal is pending here, my lord.
What is pending?
Writ appeal, my lord, in relation to a service matter challenging the POSH Act, my lord. My lord, the order sheet is produced herein with the memo, my lord. Kindly post it at the earliest, my lord. At page 2, my lord. On 27/6/2024, my lord, this
So
is
you want to list it before learned single judge?
to be tagged along with the writ appeal, my lord. Therefore, it is requested that writ appeal may be listed at the earliest, my lord.
Any order is passed by learned single judge?
No, my lord, the order was such that the matter may be kindly be referred here and clubbed with writ appeal.
So this will be placed before the Chief Justice on the administrative side, not by this, by order, by memo. You approach the Registrar Judicial and the appropriate things will be done, right?
Much obliged, my lord.
This 5.
But I appear for appellant, my lord, in this case. There's only one indulgence one I'm seeking, subject to what lordships will. What I am instructed to state, I'm bound by I'm liable to be corrected, that Midcon lords, which is the main appellant, Midcon, is shown to be represented by one of its director, Shrikant Bhangdia. There are two directors. One of them has been arrayed as a respondent, and one of them is represented by one Shrikant Bhangdia. The entire appeal, my lord, and application for stay, etc., affidavit, is sworn to by the first appellant, the Power Smart Media Private Limited, whom the allegation is, my lord, that they are the ones who have taken it over without an authority.
Then is affirmed by
the first appellant, Power Smart.
Power Smart.
Power
No,
Smart has.
Power Smart is what is the role of this? I am not able to gather.
Power Smart, my lord, the allegation is that the original license holder is Midcon, and without any authority, Power Smart is run.
There is no such pleading.
No, that is the entire case is that only. Entire case is that only. In the petition, our case is that original license holder was Midcon, and Power Smart without any authority is running it. Therefore, that violates the
Power
broadcast.
Smart is running the channel.
Yes, yes, that is our allegation.
So that is your reply. Reply is filed in the petition.
Yes, that is part of the petition. That is part. But only one request we had was that the instruction subject to correction was that Midcon is not before the court at all. They say it is represented by one of its director, but the entire affidavit to the application, etc., is sworn to by Power Smart. He is the one of the subject to be corrected. If Midcon is
Affidavits are sworn by the directors of
Power Smart
and not by Bitcoin.
Not Midcon at all.
So Bitcoin is projected to be the.
Yes, yes, and Midcon is not before the court. Subject to correction.
My lord, that's not correct, my lord. The Mr. Rakesh Shetty, my lord, who was sworn to this, has, my lord, there's an appointment letter in his name in appeal number 951 at 227.
Yes.
It's given by the company Midcon.
So 957, 951 is
Yeah.
by whom? By Power Smart.
Both of them are
both-
same.
In both the
Both
appeals.
by Power Smart.
No, my lord. Power Smart is first appellant, Midcon is second appellant.
And both in both ways.
In both appeals. Only writ petitioner is different. So there's an authorization letter by which, my lord, this Mr. Rakesh Sanjeev Shetty is the chief executive officer and anchor of the media partner.
No, that there is no authorization to that effect that he can represent the company in any legal proceedings, including the present appeal. I don't see that. This is an appointment letter appointing him as chief executive
But
officer.
this was not raised
Not a question
anywhere.
of, no, it has serious implications, my lord. If Midcon doesn't come before the court, the original licensee, the entire appeal fails. But of course, my lord, it is not just mere technical aspect. Our case rests on this question that it is all along Power Media which is prosecuting it on behalf without any authority.
My lord, there are two appellants. Midcon, my lord, Wakalat is signed by the director authorized by it. The application, my lord, is signed by the chief executive officer.
Wakalat is signed by whom? Sir?
By
Sorry.
director. Midcon director.
Huh?
Wakalat is signed by Midcon director pursuant to a resolution.
Anyway, my lords, I just wanted to bring. I will not tell.
So writ appeal number 949 of 24 with 951 of 24. These two appeals arise from two different but verbatim same from orders passed by a single judge in the respective writ petitions. The first mentioned appeal number 949 of 24 is referable to order passed in writ petition number 10639 of 24, whereas the other writ appeal pertains to the order in SCA number so and so and so, that is 10553. 10553, just check it. Yes. So appellants are common in both.
Yes, yes, both common appeal.
The appeals are by two appellants. Named Power TV, Messrs. Power Smart Media Private Limited, and Messrs. Midcon, MIT, CON, Infra Project Private Limited, respectively, from who are the original respondent number 2 and 3 in the writ petitions. Verbatim same order dated 25/6/24. Since the facts in both cases run parallel and are similar, and the issues are identical, both the appeals were taken up, were heard together to be disposed of by this common order. Addressing the challenge paragraph to order dated 25/6/24 in both cases, passed by a single judge. Addressing the challenge, both appeals impugn two orders of even date dated 25/6/24, passed by a single judge in the petitions concerned. The orders are interim orders, passed pending the final adjudication of the petition. It appears that paragraph, respondent number 1 in the writ petition, Power TV, faces certain allegations and the consequential notices for alleged violations of law. During the pendency of the proceedings of the petitions, when show cause notice dated 9/2/24 was produced before the court, and in light of that development, learned single judge passed the interim order. The operative portion of the order in paragraph 7 is extracted herein. Then quote paragraph 7, under these circumstances. Release this matter on 9/7/24, up to that. The aforesaid order directing the Discount #1 Power TV not to continue with any broadcast to restrain the private respondents from carrying on the broadcast activity till the next date of hearing. Came to be passed by law on a single judge upon noticing and observing certain aspects figured in the controversy. It would be necessary, paragraph 2, notice the basic facts operating in the background. The first petition, first writ petition number 10639/24 came to be filed by the petitioner who is stated to be in police service, serving in IPS cadre, whereas the petitioner in the other petition, from which writ appeal number 951/24 arises, happens to be member of Legislative Council. Drawing the facts from the first petition, it is the first petition relatable to writ appeal number 949/24. It is the case of the petitioner that the two appellants herein are the owners and run TV channel in the name of Power TV. It appears that it is the allegation that it is appellant number 2, Messrs. Bitcoin Infra Project Private Limited, which claims to have the authorization to run the channel. However, the channel is run by appellant number 1. Channel is de facto run by appellant number 1, Messrs. Power Smart Media Private Limited. It was pleaded in the petition that on 8 September 23, respondent Power TV released and broadcast certain promos which, according to the petitioner, were defamatory and derogatory, lowering the reputation of the petitioner, and that the story broadcasted in the promotional programs was concocted story created against the petitioner. Be as that it may, full stop, paragraph. It was further stated that in that view, the petitioner had filed a civil suit being civil suit number OS 1602 of 23 in the competent court at Bangalore Rural, and that in the said defamation suit, injunction was granted against the state TV channel and the respondents. It was the case that despite the injunction, again on 22nd September 23, the TV channel and the owners thereof proceeded to telecast the news titled as Dust IPS tarnished the image of the petitioner. It was stated that the contempt petition was filed. Paragraph. The further case of the petitioner is that he filed representation dated 16th October 23 before Respond number 1, Union of India, Ministry of Information and Broadcasting, to raise issues that the owners of the TV channel and the owners had violated Section 5 of the Cable Television Networks Regulation Act 1995, Cable Network Rules 1994, as well as the relevant rules of the program code. Pursuant to this complaint, Messrs. Bitcoin Infra Project Private Limited has been facing notice from the competent authority dated 21st November 2023. It was averred by the petitioner that no response was given by said Messrs. Bitcoin to the ministry. Full stop. It is the case that the petitioner came to know about respondent number 3 company, Messrs. Bitcoin, only upon the aforesaid notice came to be issued to it. It was further stated that as no response forthcame, yet another representation dated 28 December 23 and still another dated 18th January 24. Yet another representative 28 December 24 came to be submitted by the petitioner. Full stop. The respondent, Messrs. Bitcoin, was subjected to one more notice dated 18th January 2024 by the ministry. It is the allegation in the notices issued by the Ministry of Information and Broadcasting, Union of India, that without, and it is also the case of the petitioner, that the TV channel concerned has been broadcasting the news and the programs and the other promos without having security clearance, which is not given, which is supposed to be obtained from the ministry for downlinking and uplinking channel operations. Upon such a premise of basic facts and raising various grounds in the petition, referring to the violations of, alleged violations of the law, comma, the petitioner prayed to direct the respondents to respondent number 1, Union of India, to consider the complaint dated 4/3/24, which was lastly filed by the petitioner, and to take consequently the action by stopping respondent number 2 TV channel from telecasting/broadcasting any news. Full stop. The facts paragraph involved in the other petition are similar, and pleadings contain the allegations of the same lines. The prayer made in that petition is to direct the respondent number 1 to take action for violating the mandate of the cable television networks in duplicate. Regulation. Bracket or act. The Cable Network Rules 1994 and the policy guidelines for uplinking the television channels from India notified by the respondent 2 from time to time, amongst which the last such guidelines were dated 9/19/2023. It appears paragraph that in course of the hearing of the writ petition, when learned single judge was apprised of the development about the Union of India Ministry of Broadcasting and Information having issued notice dated 9/1/24. 9/2/24. Comma. Comma, gathering the further facts, comma, interim order came to be passed, which is now impugned in the appeals. In the said impugned interim order dated 25/6/24 from a learned single judge, highlighted certain facts and aspects which are relevant to be noticed. Roman 1, 2, 3, 4. Roman 1 small. One, it was the contention in the petition that the respondents, that appellants hearing, the TV channel and the owners of the channel had been continuing the broadcast without obtaining necessary approval, public renewal of approval. And that their broadcast activity was without obtaining necessary approval. Two, proceedings were already initiated by the central government against the respondents for the alleged violations. And despite that, the broadcast was carried on. Three, submission of counsels for the respondent Union of India was noted that the proceedings have already been initiated against respondent 3, public respondent 5, and other private respondents. And that final show cause notice dated 9/2/24 has been issued. Paragraph. Final show cause notice, not paragraph, 3/4, 1, 2, 3, 4. Final show cause notice was reproduced in the order to take note of the aspect that Messrs. Midcon Intra Project Private Limited was granted permission by the ministry by letter dated 13/10/2011 to uplink and downlink a news and current affairs for the TV channel named Power Channel. State permission was valid till 12/10/21, and that the company had applied for renewal of the permission. Next, continue. The application for renewal was made on 30/12/2022, which is under examination by the ministry. Next, the communication dated 6/2/24 reflected that the central government had addressed communication to the director of Respondent 3, informing them, Respondent 3/Respondent 5, informing them that the Power Smart Media Limited is not a permitted company is not a company permitted by the ministry to uplink and downlink of a TV channel. The case of the petitioner, the case of the respondents was that the necessary renewal was obtained and that they had permission to uplink the channel. However, no renewal has been granted in favor of the said respondents. Next, no material is produced by the respondents, either showing the approval or grant of license, or that such approval or license are valid and subsisting as on date. Learned, paragraph 4, learned senior advocate Mr. S.S. Nagananda and learned senior advocate Mr. Dhyan Chinnappa with learned advocate Mr. R. Swarupanand appearing in the respective appeals seriously questioned the impugned order. They vehemently submitted that without deciding the main controversy, learned single judge has passed interim order, stopping the broadcast by the appellant's apostrophe S channel. They submitted that the development of issuance of notice dated 9/2/24 was took place in course of the hearing of the petition and did not form part of the pleadings. And that the interim order could not have been passed when effects were not pleaded. It was further submitted, it was next submitted that learned senior counsels asserted that the TV channel is being run since several years with authorization, and that it is merely on the basis of, and that it is only on the basis of mere allegations of alleged violations or that license is not taken, that learned single judge came to conclusion to direct stoppage of broadcast. Learned senior counsels proceeded to submit that in any case the renewal application is made, and when the appellants had been running the channel until the renewal was rejected, court has to view that there was a deemed permission and the broadcast could not have been abruptly halted by interim order. It was further sought to be submitted that the allegations in the notice are yet to be tested and are unsubstantiated and are yet to be tested for their merit. It was finally submitted that right to telecast through a electronic media is necessary concomitant right to the fundamental right of freedom of speech and expression flowing from Article 19(1)(g) of the Constitution. Paragraph. On the other hand,
one factor I pointed out not was a subsequent grant renewal of the uplink ports. There are 4 uplink ports that they have approved us after the issuance of the show cause notice. That your lordship saw, my lord, the last one of them was Annexure 9 at page 221, 5324.
what is granted?
That is, my lord, the government, when we apply, my lord, for change of the portal to which teleport and the location of them, both have been approved, my lord. The last approval is on 5324. That is after the show cause notice. Also, the government has permitted this to continue. The last one, my lord, after that is an uplink notification, which is a different frequency. In that also Power TV is indicated. That's the page 223, 19.3.
So submitted that the show cause notice dated 9/2/24 preceded the grant of applications, as many as 3 times, made by the TV channel for change of portal and change of location, which, according to the submission of the learned counsel, senior counsel, implied that the authorities had no complaint against the TV channel.
The pendency of the renewal did not come in the way. That's how, my lord, I would put it. That they recognized.
The council, Senate councils wanted to submit thereby that dependency of what?
Renewal application.
Renewal applications should not come in way to stop the.
No, to not come in the way of the government giving me other approvals to continue the channel.
Should not, that not, I'm sorry, I
That's
don't
my
want to,
submission.
it can't, no, I just wanted to correct this. Learned, the additional solicitor general yesterday clarified that change of teleport is not given to them. It
That's
is
my
given to the
submission.
teleporter and the document itself makes.
Only my submission.
Repeat your submission.
Two documents are there, my lord. 5324, change of teleport.
You have submitted that in view of the said aspect, there should be no bar to renew the license.
That's all.
On the other hand, paragraph, learned Additional Solicitor General of India, learned Additional Solicitor General, Mr. Arvind Kamath, assisted by learned Central Government Standing Counsel, Mr. N. Kumar, appearing for respond 1 to 4, as well as learned Senior Counsel, Mr. Prabhulinga K. Navodagi. 4?
Naveen Chandrasekhar.
4 with?
Respondent.
With?
Your name.
What your name?
Naveen Chandrasekhar.
Naveen Chandrasekhar. With Mr. I've written Naveen Chandrasekhar. Appearing for? Respondent number 2. Respondent number 2. Submitted that the
Your lordships, kindly excuse me, my lord. I have to. Wait.
Submitted that the order passed by a single judge was based on relevant considerations and cogent grounds. Learned Solicitor General, Additional Solicitor General, before that, refuting the case that the details on which the details and materials on which the order was based was not part of the proceedings, it was submitted that the petitioner was well aware about the issuance of notice dated 9/4/24 and that during the proceedings of the writ petition, not the respondent was well aware. And during the proceedings of the writ petition, the respondent took time on the said ground as many as for 3 times. It was submitted that the developments were argued and became part of the proceedings, which led a single judge to pass the impugn order. Learned paragraph. Additional Solicitor General invited attention of the court to where are guidelines? 139, 114. Invited attention to the guidelines dated 9th November 22, issued by Ministry of Information and Broadcasting, Broadcasting Wing, Government of India, which are the policy guidelines for uplinking and downlinking of television channels. Into bracket page 149 onwards in the compilation of writ appeal number 949 of 2024 bracket over. The said guidelines, it was stated, stemming from STWMING, Section 4 of the Telegraph Act, and that it had statutory force. It was submitted that any TV channel or TV broadcaster has to obtain the permission from the competent authority for uplinking and downlinking the TV news or any other broadcast item, which is, it was highlighted, it was emphasized, was necessary for disciplinary and security purpose, was necessary for both disciplinary and security purposes. It was then pointed out from page 192, 197 and 221 of the compilation into the writ petition number 949 of 24 bracket over, that the respondents TV channel and their owners have time to time sought permission for change of uplinking and downlinking, change of teleport and satellite uplink, as well as the change of locations. And that to submit that the respondents were not steady broadcasters. Learned advocate for respondent 2 highlighted that since November 2021, the petitioner does not have any license, which is an undisputed fact. He further submitted that renewal is only applied and so far has not been granted. He submitted that there is nothing like deemed approval in law. He also figured out that there are as many as 15 criminal cases registered against the owner of the director or owner? Director.
Director of the appellant number 1.
Director of appel number 1. Paragraph. The submission on part of the appellants is stated to be rejected. That learned single judge traveled beyond the pleadings, or that the relief granted cannot be traced from the relief prayed for. in the petition. Full stop. Running through the pleadings in both the petitions, it could be immediately noticed that the allegations are made against the TV channel for alleged misuse of broadcast rights, and that in that regard, upon the complaint filed by the petitioner, notices were already issued by the Union of India, calling upon to explain the alleged violations, which have remained unresponded, by the petition, by the respondents. The last representation from complaint was made by the petitioner on 4/3/24, which became subject matter of prayer of the petition. Full stop. There was also the direction to stop the respond number 2 TV channel from telecasting, public broadcasting, the news, any news, was already part of the prayer, part of the principal prayer. Therefore, it could not decide that what is that prohibition to telecast ordered by interim direction has no genesis in the principal prayer. Having regard to the paragraph, nature of order which is being passed by this court while disposing of the appeals, the court does not think it proper to delve into or decide any of the submissions of the parties on merits, it may affect their case, which is yet to be decided by the authorities. Dealing with the submission about the respondents, dealing with the submission where the respondents claim fundamental right to speech and expression by broadcasting the television news and programs, to submit that such right is taken away by law on a single judge by passing impugn order, appears to be attractive at the first blush. However, it is to be observed that all fundamental rights, including right to freedom and speech of expression, is subjected to reasonable restriction. Viewed from this standpoint, when the respondents have been facing legal notices for their alleged violations, of law and the regulations, including the guidelines for uplinking and downlinking the TV programs and TV promotions, till it is only appropriate that till the list is finally decided by the competent authority, till the controversy is finally decided and the allegations raised in the so cause notice are finally dealt with, the broadcast is prohibited. Full stop. Temporary prohibition of broadcast in light of the fact situation obtained and further in view that the competent authorities are to try and deal with on merits. The show cause notice, comma, would not be said to be violating the right of broadcast, full stop. The broadcast, the temporary phenomenon of prohibition cannot be equated with the prohibition against the fundamental right. Law on a single judge, paragraph, would be said to be eminently justified in noticing the aspects of show cause notice dated 9/2/24 having been issued to the respondents along with the other previous notices. The case against the respondents are to be tried after they would reply to the show cause notice to be decided on merits, comma. There is no gainsaying that the permission to uplink and downlink the news and current affairs accorded to the respondent TV channel was valid up to 12/10/21 only, and that thereafter there is no valid approval, although the company has applied for renewal permission, which is to be considered in accordance with law. It is in this light that a single judge passed the impugned order to stop the broadcast pending the testing of the allegations against the broadcaster and the owners of the broadcaster. Paragraph. The only wanting aspect which the court finds in the order of a single judge is that a single judge has not set down any time limit for deciding for proceedings to be concluded pursuant to the show cause notice dated in show cause notice paragraph. In light of the aforesaid discussion and the situation obtained, the writ appeals are disposed of by following directions, the respondent shall have right to reply to show cause notice dated 9/2/24.
Already replied. We have replied.
If the reply is already filed, it will be open to the respondents to file a further reply if they so choose. Such reply shall be filed within 1 week from today. 2. The competent authority of respondent 1 shall give open sub hearing to the petitioner if they so choose. Full stop. Upon such application to be made by the appellants, the personal hearing shall be given. Next, the process of personal hearing, if required, shall be completed within further 1 week from the date of such application. Next, the competent authority shall decide the show cause notice after considering the reply of the respondents within further period of 2 weeks. How much time will take?
4 weeks.
Why 4 weeks?
Please,
4 weeks. 3 weeks. Please, 3 weeks.
Lord, not only show cause notice, my renewal application also has to be decided.
Show cause notice as well as all other.
Renewal application by me.
Show cause notice.
Renewal application
Next,
is
the authority shall also decide the renewal application in accordance with law after considering the case of the respondents and considering the facts and circumstances and the case of the respondents. Paragraph. The entire exercise shall be completed within expeditiously
Then 4
and
weeks
within
from
outer
today.
limit of 6 weeks.
4 weeks, my lord. My
Or-
channel, my lord, they have all the material.
Five is there, 1 week is given for leeway, 6 weeks.
As,
Today.
as far as the renewal application is concerned, my lord, so that timeline may not be, because according to the policy itself, my lord, after receipt of clearance from MHA, within 30 days they consider, my lord, if it may.
MHA has granted clearance, my lord. My lord, on one
second. Because the policy is very clear.
MHA has granted clearance.
That I am not, no instructions
lord,
as to that.
On one hand, they now don't renew my application, and now they want more time for that. And that's the ground on which my trial is being stopped.
Your lordship, my director.
MHA is already given. That's my instruction.
Completed within 6 weeks from today. Paragraph. At this stage, Learned Council for Union of India submitted that the renewal application will require
MHA
time before the final decision could be arrived at. It is observed in this regard that the fate of renewal application will depend upon the fate of the decision on the show cause notice. Therefore, for the deciding renewal application, further 2 weeks are given.
Yes.
Correct.
After deciding the final.
After deciding
Correct.
the further 2 weeks.
No,
are
my
given
lord,
to
it should
begin
be, I'm sorry, my lord, it should be the other way about. Now, my lord, what they are saying is, because you don't have renewal.
with. Nagaranda, now then there are certain allegations, right or wrong, in the show
It's
cause
found to
notice.
be true, then the
That's
question
why
will be.
what-
They have to be addressed first before going to the renewal.
No, my lord, the renewal application has nothing to do with this, my lord. The renewal application was filed in 2021, 22. Now from 22 to 24, they keep it hold.
Now at this stage, renewal cannot precede.
If the allegations are found true,
Let
my lord,
them
the question
decide
of renewal
everything,
does
my
not.
lord.
That is what.
No, my lord, let them decide everything, my lord. Otherwise, it's only going to be further delay.
So then entire exercise shall be complete within 8 weeks,
Yes.
without that, let's say, sentence.
Yes. 8 weeks.
Do it in your own way comprehensively.
In accordance with life.
My lord, MHA clearance is given, my lord. I don't know why they have, my lord, not noticing
I
that.
don't know. That is.
6 weeks,
have no
I'm stating.
Is given for teleport, not for the renewal of.
We keep it, why can't you do it in
6 weeks is more
everything?
than enough time.
6 weeks.
Please.
6 weeks enough time.
Extension.
More than 1 month, 1.5 months. right?
Yes.
So 6 weeks. Entire exercise, comprehensive exercise shall be undertaken and completed within 6 weeks from
Please.
today. Paragraph. It is observed and clarified that this court has, while noticing the rival contentions, has not expressed any opinion on the merits of the case of the other side, since the issues at large before the competent authority, issues are at large before competent authority to be decided finally. So you have to, whatever you want to take, security clearance, etc. May take.
Sometimes if timeline is fixed in this regard, you will go according to the policy matters that, according to policy that issue may be decided. So that.
So everything is up to you now. Only thing that we have maintained the last.
Apply.
Anything more? In fact, this marks the, in view of the above schedule and timetable fixed for deciding the show cause notice and for consideration of, and for decision on the renewal application, the next date of hearing of the petitions before a single judge is deferred to after 6 weeks.
Lord, in the light of this order, that petition may not survive.
That is what we
So
are.
we will let it be on that day, my lord. We'll produce a copy of the order requesting the learned judge to close it.
Today it will not survive.
Yes, my lord. Your lordships can withdraw and close it.
Well, but we will persuade the learned single.
There only.
No, it can be withdrawn and closed, my lord. The prayer is to consider. Your lordships have not granted it now.
There will not, if it is for you, like we
Yes,
can
my
say
lord,
that.
we will file an appropriate affidavit.
We can say that in view of this order, nothing survives in the matter.
Exactly, my lord.
Definitely.
Lordships may say so. Lordships may say so.
Ah.
Lordships may say so. Nothing survives.
The parties shall the decision which may be taken by the competent authority as above shall govern the rights of the parties.
Yes.
With their further right to approach the higher court oblique forum.
Yes.
If the decision is adverse against either of the parties. Full stop. Any of the above arrangement and the order passed from a learned senior counsel for the parties, learned counsel for the parties would not dispute that substratum of the petition petitions itself would not survive since the above directions are received. Full stop. Accordingly, along with the disposal of the writ appeal, two writ petitions are also stands disposed.
Please.
Your lordships may formally withdraw them and dispose them, Lord.
On the same lines.
Formally withdraw them before the bench and dispose.
The records may have to be called for.
A formal order.
Under appellate court, we dispose.
Yes,
Very well, you can, your lordships can.
You can go to learn a single judge and say there is no.
Yes.
Formally, my lord, what orders your lordships would make is, when the honorable division bench feels a writ petition is be withdrawn to the bench, your lordships would say the writ petitions are withdrawn and disposed.
All right.
That's all.
Before
Yes,
us.
by your lordships.
By your lords.
Your lordships, my lord, by the honorable division bench.
In fact, we have power as the appellate court.
Yes, yes, continuation of the original proceedings.
So
They are continuation.
they can withdraw here,
Please.
not survive in that view.
That's a formula.
No, in light of the above order, the writ appeals would not survive. Themselves are unable to dispute the said aspect. In that view, they withdrew. Learned counsel petition withdrew the respective petition.
Please.
They stand accordingly disposed of along with the
Please.
appeals on the same lines.
Please.
Great.
For formality only, I am saying, my lord,
No.
that would be before the learned single judge. So your lordships can withdraw it and dispose.
You
That's all.
have right to teach us.
Please.
You are senior and we learn, always learn from.
Great.
Only thing that in Gujarat we use.
Inshallah. I'm sorry, my lord, if I gave that impression. I didn't
Yes.
have any such thing,
No,
but
no, no.
I'm only telling your
We are
lordships
setting
what
it
the
with-
practice in this honorable court has been.
By all means, we are saying.
That's
not
all.
just for-
Otherwise, it's your lordship's discretion.
Yes, there will be some fine tuning here and there in the order.
Lordship, please.
In view that the petitions are disposed of as well, they shall be listed on board today before this court for formal purpose, for formal purposes of showing the disposal.
The subtitles I have reading you only.
Anything you have. Yes.
Still number one, to be mentioned matter, Sir Rajendra Kumar Shunge. Still number one,
This was heard. Ah. Where is that matter? 461. The common order. Order was common. Same thing. The same.
Contempt matter, still number 2.
Notice
for complainant.
Notice 8th August.
My lords, on 11/6/24, my lords are directed respondents to comply with the directions of learned single judge.
Notice
This matter was listed yesterday, my lords. My lords had directed them to secure
So
instruction.
not issued. Any.
No, my lords.
Lords, it has been considered, my lords. It's in Kannada. My apologies.
That only this means. Sorry.
That's, if I may submit regarding the endorsement. It only states that since this being a grant land, my lords, the relevant documents pertaining to the grant records are submitted, the Podi and Durasti will be conducted within 4 weeks, my lords.
Documents are not available.
Lords, the learned single has mentioned that it's an online application. So far as grant lands are concerned, online application is not permissible. It is, 1 to 5, we call it, my lords, under the act. So that has to be submitted. Once
Its
that is
contempt petition, the court had the occasion to pass the following order on 11/6/24. Then got this order to posting. When the petition comes up for consideration today, learned additional government advocate, Ms. Pramodini Kishan, produced endorsement dated 1/7/24 to state on the basis of the sections of the said endorsement of the order that the directions of the body would be complied with within 4 weeks.
Lords, once the documents are submitted within 4 weeks.
6 weeks. 6 weeks. Yes, yes, that we are observing. It was stated that the time is needed to decide the application of the complainant in view that the application made by the complainant was online. And since the land was a grant land, the online application is not permissible.
Please.
Full stop. At this stage, learned advocate, Mr. So-and-so, the complaint states that the complainant will make formal physical application to the competent authority in 1 week.
Please.
In 1 week.
Please.
And also submit necessary documents as may be required by the respondents.
Please.
Stop. Once the exercise is undertaken, within 6 weeks' time, as stated above, the necessary decision will be taken by the competent authority. With the aforesaid observations and in view of the endorsement dated 1/7/24, the present contempt proceeding does not survive and stand disposed of. Full stop. The endorsement of the order dated 1/7/24 shall remain on record.
My lords, liberty to revive the contempt petition. Liberty to revive.
Away to send liberty. No liberty is reserved to revive the. There is no contempt now. In the aforesaid view, it cannot be contempt. It
My
cannot be
lords,
said that.
at
any
the
contempt,
instance of government
much less
advocate,
the
online
willful
application
contempt-
was submitted.
Much less any willful contempt is committed by any of the respondents. The contempt proceedings are accordingly closed. You file a petition to challenge the order, not contempt petition.
Please.
Yes.
Number 3, Mr. Vasant Kumar HT. Number 3, Mr. Vasant Kumar HT. Green bench matter, still number 4, Mr. Shivraj Generally.
Please pass out this. Now, madam, you have seen one order. It will take care of
Pass
the
over.
entire group. What about this order? Any further order is passed? Any contrary order is passed? Appos. These two. For hearing. So tomorrow.
A copy may be served to us.
Copy, give copy to. You just find out what are the orders governing.
I'll take instructions in this matter. Okay.
5-6 are disposed. Still number 7. The writ appeal matter, the Kiran BS.
The appellant in this case. So there is a 24 days of delay for filing a writ appeal on the reason of health grounds, madam. The appellant had an kneecap fracture. So the doctors advised to take in 6 weeks of
Delay of 24 days, but there is nothing in the appeal. Instead of 25,000, 10,000 penalties.
Yes. Yes, ma'am.
Dismissed.
No, Your Honor.
While
If I may, Your Honor.
in the facts of the case and having regard to the fact that the papers of the main
My lord.
writ appeal along with the impugned order of law.
My lord, there is an,
available no record, both. Delay condonation application, which is for delay of, for condoning delay of 24 days, as well as the main writ appeal could be adverted to
My lord,
simultaneously.
there is a question of law in this case. So we have furnished the information which is seek for through RTI. But by impugned
you are
order
public-
dated 7/3 of.
You are
2000
public information, you are public information officer?
Your Honor.
You are public information officer
Yes, Your Honor.
of which body?
I'm a doctor in the Kidwai Hospital.
Doctor in
And also the HOD of the department.
So why should we interfere in the discretion of the learned single judge who has reduced the penalty from 25,000 to 10,000?
Your Honor, the single judge has noted that the petitioner did furnish the information sought for 5th respondent. But if you see the annexure G, my lord, the writ application was filed on 23
Noticing
of
the merits
2013.
of the impugned order straightway, respondent, this appellant petitioner, anything to be submitted? Anything material to be submitted, we are dismissing the appeal.
Kindly adjourn the seek for short accommodation.
Why?
My senior will come and argue regarding the
2:30. 2:30.
2:30. Much obliged.
No, itna लिख के रखो. Adverting to the merits of the appeal state. Comma.
Eight adjourned. Still number 9. Mr. Parashuram R.
My lord, this is the.
Appearing in favor of appellant, my lord. Kindly praise 1 week time. Kindly praise 1 week time, my lord.
No time. Group is there. Along with the group at 2:30.
Still number 10. Sir, appeal by government.
Lord, I appear for the appellants, my lord. My lord, this pertains to the challenge to Act 7 of 2014, my lord. Similar writ appeals are filed in WA 2476 of 2015, my lord, and they are posted before a specially constituted bench. This writ appeal may be tagged along with WA 2476 of 2015, my lord.
Like to be listed.
My lord, there is a delay of 562 days in filing the appeal.
Sorry, notice then. 562 days. Notice returnable on 7th August.
Obliged, my lord.
Number 11.
11 MIA number 1 of 24 and 224, which are for production of additional documents, are disposed of. By observing that the consideration or otherwise of the documents sought to be produced will be decided at the time of hearing of the appeal. Appeal may be listed on 30th July. Next.
Number 12. Number 12.
Yes.
The Kumar Swamy HC.
My lord, this had 230, my lord, along with the matters in the second list.
Second list.
Number
This may be taken up separately at 13 number. 13 is 12. Yeah. And give it to me. Different issue. Madam, 12 is different issue. We'll just take
My
up.
lord,
But 12 is not that part of the group.
my lord, it's SC/ST matter, my lord.
But issue is different.
A little different,
At
but
2:30 we'll take up separate.
yes. My lord, it was second time two writ petitions have been filed. Considering that the earlier writ petition had been disposed of, my lord, it was held that the second writ petition could not have been entertained.
Sir, review or fail, tell it.
Yes.
13.
Here for the appellant. There are two writ appeals connected. Issue is very short, actually.
This matter, my
Before
lord,
I-
on the last occasion when the matter came up, the appellant said that we will file a review petition before the single judge. On that ground, it was adjourned.
No such. That was just something that was said in passing. There's no such application intended. I'll briefly explain the facts, my lord, then I'm in my lord's hands. Before I take my lord through the appeal memo, the issue in this matter is only this. The appellant is an earlier grantee of certain land. The contesting respondent has also been granted certain land in the same survey number. In that process, my grant is sought to be cancelled. That is what is being questioned here. Repeatedly, this court on earlier occasions has said that the grant in favor of the subsequent contesting respondent could be considered without disturbing my grant. Eventually, the revenue authorities seem to conclude that there is no record of the grant in my favor, and that is what a learned single judge also agrees with. The finding of the learned single judge is very short, simply agreeing with the revenue authorities that there are no records of a grant in my favor. Lord, very quickly, I take my lord to the relevant.
Where is the order of the tribunal?
The order of the tribunal, my lord. That will be in the other petition. 240. Tribunal.
242.
Yes, my lord, at 265, second volume, in WA number 106. WA number 106, second volume, page 265. My lord, the relevant portion my lord may find at 286.
It is sent back.
That could also be done.
Tribunal sent back.
Tribunal gave a finding that my grant should not be disturbed. The finding of the tribunal is at 286.
While returning the case to number 2. So it is remitted back. Go to page 288.
Yes, my lord. That's right, it has been. But with the finding that the grant, my grant should not be disturbed.
We'll say that finding will not operate as binding.
No, my
but
lord.
He says to go back. It
No,
is
no.
overlapping, simple.
But
very
what
simple.
happened was,
That is true.
that
That is what I've been
there is
saying
one
all
more order. There is one more order where they say that there is no such grant at all. Kindly see the affidavit of the.
Everything will be examined by the competent
No,
authority.
my lord,
that
the
is under-
finding is they have the petitioner, the appellant herein.
Area is overlapping.
Areas are overlapping is my contention.
My lord, he
My
said-
grant is earlier in time, any
Yes.
grant subsequent
No,
to them?
it is not a case of remand, my lord.
Entirely fact.
There is no grant at all. That is the finding of the authorities.
What is granting?
My lord, he claims that he is granted about 2 acres of land. Whereas I claim, my lord, about 3 acres of land is granted to us. Now the Tahsildar, Assistant Commissioner, Deputy Commissioner hold that there is no grant at all in favor of the appellant.
Because of overlapping.
No, not overlapping. Kindly see, my lord, that is why the affidavit filed by the Tahsildar, which is at page 114.
In fact, my lord,
Because of overlap.
while making that order, the deputy
let me
commissioner
see
also
the-
ignores the fact that certified copies of my entire records
Kindly
were
see
obtained from the
114.
Tahsildar's office and presented before him.
So you were appellant before the tribunal? No.
I was appellant before the
He was
tribunal.
appellant in a parallel proceeding.
My lord, I'll explain. My lord, I have filed a synopsis that may help, my lord, with a list of dates and events.
But your lordship, just see, I will only refer to 2 documents. Now, this affidavit says that there is no grant at all in his favor. Where is the question of remand, my lord, to consider overlapping? This is confirmed by the Assistant Commissioner as well as by the Deputy Commissioner by separate order, which has been questioned before him. Kindly see page 175, my lord.
That is your defense. You are not the appellant before the tribunal.
No.
Defense.
Before, there are 2 orders passed before by the tribunal. One is, my lord, in respect of this to remand the matter to decide overlapping. There is another parallel proceeding where the authorities have held there is no grant at all in favor of the present appellant.
That is contrary to the
That order, my
record.
lord, is also there. There are 2 writ appeals. Kindly see page 175. That is the order passed by the authority saying that there is no grant. It is a question of finding of fact. And further, my lord, he has sold the land also. The present appellant suppresses the fact that he has sold the land. That is also, single judge says that there is a suppression of fact. He does not disclose that on the basis of this non-existing grant, he also executes sale deed and then comes before the authorities.
But it was already granted to the appellant.
I have been granted.
Yes, my lord.
I
It
have
was
been
earlier granted in my
land.
favor.
No, that grant, my lord, itself is a forged document. Is the finding of the authorities. Saying that he claims that there is a land grant in his favor by a special deputy commissioner. That office itself did not exist. No such records are found in the Darkast records. That is the finding of the Tahsildar, confirmed by the Assistant Commissioner, and once again confirmed by the Deputy Commissioner that there is no such grant at all.
In fact, my
That is
lord,
the
may-
finding of fact, my lord. Where is the question of going into that issue when there is no grant?
lord, there are previous orders confirming my grant pursuant to an inquiry in 2011. In fact, my lord, there is an observation of this honorable court in an order at ink page 234, concluding that the records of my grant are available before the DC.
Sells away all his property and comes before the court without disclosing that he has already sold the property.
How do you say it is overlapping?
My lord,
There is no finding anywhere.
no, there's no finding on overlapping. What the authorities subsequently say is that my records don't exist. Whereas before the DC, certified copies of my records have been produced at page 338. There is an order passed by the DC to the Tahsildar to furnish records relating to my grant, and the Tahsildar produces those records. But then he goes on to pass an order saying that those records don't exist.
On the contrary, learned single just said that you produced and relied on grant certificate.
That's right.
It was fabricated document.
That's right.
See the finding.
There is no such finding. My lord will see at page 338.
Page
That's
52.
true.
My brother is rightly pointing out, page 52.
That's
internal
that's the incorrect finding. My lord will come to page 338. 338, my lord will see.
If it is incorrect, then it is question of fact.
My lord will just see.
We can't go into
No, the learned single judge has fallen into error in believing the revenue authorities when there are contrary records. The Tahsildar has produced records of my grant before the DC.
Your case of overlapping is only to overcome this aspect.
No, I have not set up the case of overlapping, my lord. The courts and authorities have said my grant should not be disturbed.
We want to know that where the court, either tribunal or learned single judge, has stated that it is a case of overlapping.
This is not a case of overlapping, is not my case. That is not my case. My case is my grant is genuine. If any land has to be granted to them, it can be granted anywhere else. I have not set up a case of overlapping at all. It is the appellate tribunal which says so. But what is the issue is this. In the issue is like this. In 1962,
Notice to the respondents. Returnable on.
July.
23rd July. Learned additional advocate.
My lord, I take notice for respondents 223.
223. On the returnal date from a learned additional government advocate shall be ready and shall be taking instructions to answer the query of the court, including on the aspect whether the grant certificate of 1964.
1962.
62.
In favor of the appellant.
Standing in favor of the appellant hearing was a fabricated document.
Well, that may not be necessary.
That is the finding we want to clear that.
Very.
This observation and the requirement to be satisfied by learned additional government does not reflect anything on the merits of the case of the others.
Very well. Because there are already findings of fact also that the records exist.
It is a material aspect, so we may clear it.
It has to be, I have to satisfy my lord.
You are a learned advocate, Mr. So-and-so, accept notice on behalf of?
No, Milord, I'm briefing the learned senior.
Prajwal
K. Aradhya. I'm briefing the learned senior.
Correct, you will accept notice on whose behalf?
On behalf of the respondent, Milord.
Which respondent?
Respondent number.
Respondent number 1. 1. Sorry, 4, Milord.
Interim order to be extended. There's already an interim order. It's there.
Interim order already operating shall continue till the next date.
Grateful.
1111.
111 the respondent.
Milord, the date, Milord.
Let's say date maybe fixed.
Date is 23rd July.
23rd July.
23rd.
Number 14.
Cell number 14
Government.
is a
You
state,
should appear for the respondent.
Lords, 14 is a state writ petition. Challenging, my lords, the order passed by the learned single judge. My lords, the order is at page number 22. Lords, matter relates to the Karnataka State Temperance Board, which was the respondent number 2, my lords, before the
You don't have case in view of the earlier order passed.
Lords,
Writ
that-
petition number 106.
Lords, the learned single judge is referred to that case, which is Adarsh Institute case.
No,
Lords,
no, not the others in dispute.
Please, that is Adarsh.
Paragraph 7.
Please, my lords.
If it is others, it is others.
Please, my lords.
Others is ideal to follow.
Please, Lords, WP, this, it is very clear.
Others means ideal. Isn't it?
Lords, Adarsh is a different order, which is at para 11. I'm sorry.
Others is ideal. An ideal to follow. Dismissed with cost of.
Lords.
You are harassing.
No,
Nothing.
Lords.
There is absolutely nothing in the.
No, Lords, here,
You
they,
tell us what is the argument.
Lords, the argument is this: the Karnataka State Temperance Board is a board, my lords, which is constituted by an executive order, my lords, of the state government.
Sir, you read the order, page paragraph 7, passed
Yes,
in
my
the
lord.
earlier petition. That
The
is the-
petitioner,
That is others. You read it, read it. Read
Lords,
it.
I'll read para 7, my lords, para 7.
Kindly read it.
The
Then
petitioner
this-
had thereafter approached this honorable court in WP number so and so. My lords are referring to para 7.
It is very clear
Please, my lords.
that the said order of this court,
Please,
dated
my lord.
22/11/22, that the respondent number has to, that is yourself, has to extend the pensionary benefit to the petitioner who falls on par with such employees or other boards. If this order is final,
Lords, they are not on par.
irrespective of any provision, you are supposed to.
No, Lords, they are not on, our cases, they are not on par. Lords, they're,
You can't now, you have to challenge this order. You can't contend in.
No, Lords. Lords, Karnataka State Temperance Board,
You can't contend that once there is an order of the court. High
Lords,
court.
para 11 may kindly be seen, para 11 for a moment.
Let us,
The petitioner, para 11 may kindly be seen.
yes.
The petitioner also places reliance on the judgment rendered by the learned single judge of this court in WP number so and so in relation to Adarsh Film Institute. This was the judgment which the learned single judge, my lords, has referred to, my lords, to give relief to the petitioner. Now, Adarsh Film Institute was an aided institute by the state government where KCSR was specifically adopted, my lords, by the institute. Karnataka State Temperance Board was a temporary board that was constituted by an executive order by the state. And my lords, 13 my lords employees were sanctioned. They are not a part of the department of the government. It is an autonomous institution. KCSR specifically excludes under a particular rule, my lords, that aided institutions, my lords, pensionary benefits are not provided. Learned single judge says KCSR is adopted, but if KCSR is adopted, KCSR provision itself is excludes.
Tell us this order in writ petition 106 of 14, which we read out, is challenged by you or not?
Earlier order not challenged.
106 of
Earlier order
2000
not challenged, 106.
Please, my lords, 106 my lords of 2014, where at paragraph number 7, my lords, that order has not been challenged. My lords, this order, with all due respect, my lords, it is very clear. I'll just read, my lords. It is very clear from the said order of this court dated 22/11/2012 that the respondent number 2 has to extend the beneficiary benefits to the petitioner.
Only one question is left.
Please, my lords.
Whether to dismiss the appeal with cost or without cost.
My lords,
Sorry.
my lords, I understand, my lords, it's my lords, it has ramifications, my lords, financial ramification, the state for this reason. Now they have, my lords, it is a different, it is a totally different organization, my lords. The other boards, my lords, have different rules.
Order of the court which has become final, no financial implication. It is your business, dismiss. It is final order. We bound, you are
My lords,
bound by.
that judgment, with all due respect, my lords, that had become final inter partes, my lords, but it said with regard to on other boards. Now, my lords, Others Film Institute, my lords, specifically provides that it is a different category, my lords, of.
The High Court says in an
Please.
order which is final that he is to be treated at par and to be paid pension, that is the end of the matter. You can't argue anything unless you challenge that order. Very simple proposition. Even then.
Lords, the one submission.
We are not going to change our order.
Please, then I'll leave it at.
You are welcome to make submission. Because this matter is as clear as daylight in our case, to be dismissed. You can test it, no difficulty.
Please.
Remedy is available, yes.
Number 15.
Lord,
Question
15
Basara.
appearing for the appellant's counsel.
Yes.
It's a bank employee. Appellant before your lordship is a bank. Now, my lord, the domestic inquiry compulsory retirement order was passed. It was confirmed in the dispute under section 70. Appellate tribunal set aside that order and directed reinstatement with 100% back wages and continuity service. That was confirmed by the learned single judge. My lord, my submission before going into the merit of the matter. Now we have reinstated. He was retired from service. We wanted to settle amicably between the bank and the employee by paying the lump sum amount, my lord. That negotiation we wanted to put into effect. I've already deliberated between my learned friend yesterday. We wanted to close amicably between the bank and his former employee. Financial implications are there. Therefore, I wanted to negotiate with the employee and we wanted to close it by amicable settlement. 100% back wages have been awarded.
When he was dismissed when?
He was dismissed, my lord, in 2010.
2010.
Then he was reinstated by implementing the order.
Today you are reinstated?
My lord, he retired from service also.
Yes.
I got retired also.
After reinstatement, you were retired?
Yes, he was
After reinstatement.
So only question of 10% back wages.
No, 10% interest on entire back wages is the order of the learned single judge.
Where is that?
No, your lordship may kindly see me.
10% interest.
10% interest on all the back wages. 100% back wages have been.
You are paid back wages?
What my learned friend say, senior says that he will interfere and he will see that the matter is settled by.
You are settling, then very well.
That's,
If not settling, then answer our query. Are you paid the back wages?
No, my lords, I have not paid any back wages. It's not paid any
So
back
are you willing to forego 10% interest?
interest.
Ask the heirs of the deceased.
Consult my party and I'll just.
That is the main contention.
No, it is not. I wanted to back wages to be reduced to some extent, my lord, it is a 50%. It's a bank implication, financial I will deliberate with him, my lord.
So you were dismissed when?
In 2010, my lords, I was
10.
dismissed in 2000.
Reinstated when?
In 2021, my lords, I was
21.
reinstated. Please.
And retired when?
Retired after, after 1 year, my lords.
22.
22.
So it is a question of back wages up to 10% from 2010 to 22.
Please, my lords.
So what is that amount?
Your Lordship.
What is the amount we are supposed to pay as
My
10%?
lord, I have to seek instruction, make my submission.
Then your grievance is that you are not with the.
We are, my lord. Yesterday, it's only deliberated with my learned friend.
Your grievance is only about 10% back wages and interest.
No, no, no. It is 100% back wages have been awarded, not 10%. Reinstatement with 100% back wages continue.
Then what is the amount to payable?
That, my lord, I will calculate. I wanted to discuss with my learned friend.
Comes around.
If he give us some proportionately, my lord, we will agree with that. Issue I wanted to sort it out by balancing the interest of both employee and the bank.
It was some pursuant to some misconduct.
Beg your lordship. Misconduct. It's a financial misconduct, irregularities. The savings bank account was paid the realized check without there being enough sufficient funds in his account.
The proposal is not bad for negotiating.
Let's, because let him tell whatever the proposal is there, my lords, I'll put across, my lord.
Shall we record or simple is adjourn?
Beg your lordship.
Shall we record about your
No, instead of recording, my lord, let it be simply adjourn it by
joint request of both the learned advocates? Send over to
2 weeks.
9th of July. Or 29th July.
Please.
Delay of 99 days, my lord, I think it could be condoned, I hope.
If we are negotiating, where is the question of it?
Very well, I leave it to your lord.
Number 16.
First respondent is only a formal party. Let joint register of cooperative society. Let government can take notice for that. It's only a formal party.
Are you serious to negotiate?
We are very serious.
Then no notice at all.
Very serious.
Number 16. Harish VS.
Even employers appeal, my lords, challenging the interim order passed by the learned single judge. In terms of section 17B of the Industrial Disputes Act, my lords, when there is an order of reinstatement granted by the labor code, and that is challenged by the employer in writ proceedings, during the pendency of the writ proceedings, there are two options, either to reinstate the employee or in lieu of reinstatement, the wages have to be paid for the sustenance. 17B application was filed by the employee, and in pursuance to that, the learned single judge directed me to reinstate. I have reinstated the employee. There is no dispute on that. She works for 6 days. Thereafter, she goes absent without any authorization. A memo is also served on her for unauthorized absence. She doesn't want to report to duty.
Reinstated.
Reinstated. I have reinstated.
Then why 17B is directed?
Thereafter, she files yet another application. Second time, she files one more application saying that she wants wages and she doesn't want to report to duty. On the contrary, I have issued a memo to her for unauthorized absence, my lords. Without considering any of these facts, the learned single judge orders payment of wages as against the reinstatement which was enforced by the order of the learned single judge. So the short question before my lords is, once there is an order of reinstatement allowed by the honorable learned single judge, whether that could be substituted with the payment of wages is a short question for consideration before my lord. And in fact, in one of the documents in reply to the unauthorized absence memo, she says that I want to report to duty, I am willing to work. Without considering any of these factors, the learned single judge simply says that you have to pay the wages.
Finding is that what is observed by learned single judge is that you did not permit him to unduty.
No, that is wrong finding, my lords. Thereafter, I filed an application seeking modification of that order with all the materials on record. Even those materials have not been considered by the learned single judge. In fact, if your lordship sees one last letter filed by the employee, which your lordship will find at page number 225 of the appeal memorandum, she categorically, specifically says that she is willing to work. Kindly see page number 225, the conclusion at page number 226. The last paragraph at 226. I once again request you to give employment to me in due compliance with the order of the Honorable High Court of Karnataka. Otherwise, it will amount to contempt of court order. She is willing to work.
Main petition was against the labor code.
Labor code.
Oh, reinstatement directive,
reinstatement direction
reinstatement with back pages.
with back wages,
What are the back pages? 100%.
100%.
But today he is not in service.
She's in service.
He is not reinstated.
I have reinstated, she has remained absent.
A disputed question of fact.
And she categorically says, I want to report to duty. She is threatening me, if you don't reinstate me, I am going to initiate contempt. On the contrary, she is willing to report to duty. I am also willing to reinstate her. I have already reinstated her. I am continuing to willing to reinstate her. And she also says that I am willing to report to duty. She wants to work. Kindly see the last paragraph. I once again request you to give employment to me in due compliance with the order of the Honorable High Court of Karnataka, as otherwise it will amount to contempt of court order and you alone will be held responsible. It is not a case that she wants to stay away from employment. She wants to report. She wants to come back and work. She was terminated on the ground that she was found leaking information to all my suppliers, my lords. So when she was reinstated by order of this honorable court, I have given her a separate cabin. She is given a separate cabin with all the facilities. She confirms that, she admits that. And now she says that none of the employees are talking to me, the management is not talking to me, the employees are not talking to me. So therefore there is a humiliation. If the colleagues are not talking to her, what is that management can do, my lords? Can that be a ground for her to stay away from duty? She has narrated the events after reinstatement. Kindly see 185, my lords, page number 185. May you take my lords to page number 185, my lords.
Yes.
Page number 185 for a moment, my lords. Kindly see page 185. 185. That is after her reinstatement, she has narrated the events which transpired in the business premises, my lords. Page number 185.
185.
185.
Yes.
The last paragraph, while entering the gate, the company security informed through intercom that Merlin has come. HR manager instructed him to send me to reception and I proceeded towards the reception area. HR manager asked me to keep my mobile at the reception and instructed me that I can use my mobile only during lunchtime. And after using it should be kept back in the same place. But where in the entire office, staff is allowed to carry their mobile to office, but I was restricted. After keeping mobile in reception, HR manager took me to first floor where there's a testing dark room next to the R&D department. I was instructed to sit in this empty room. In this room, there was only a chair, table, one fan, 3 tube lights, intercom, CC camera, which was directly focused towards the seating position, nothing else. I felt like this empty room is prepared only for my enrollment. HR manager informed me that if I need anything, I can call him on intercom, his intercom number, and he will arrange for the same. He also told me that milk, tea, coffee, and water has been arranged in this room itself, and there is no need of me going anywhere. I told him that I have carried a water bottle with me and nothing is needed. Thanks for arranging with a smiling face. And she says that this is not a conducive environment. Everything is provided to her. Kindly see at page number 187, the penultimate paragraph at page number 187. During lunchtime after work, there were few of my colleagues who spoke to me, but I found that even they were scared to speak to me. The reason behind is not known.
Advocate Mr. Harish V.S. for the appellant herein. The present writ appeal is directed against order dated 10/7/23 passed below interim application number 1 of 2022 in pending writ petition number 432/21. The order impugned is an interim order. Paragraph. By virtue of order, the petitioner appellant is directed to pay wages to the respondent workmen under section 17 capital B of the Industrial Disputes Act 1947. In the interim application, the prayer of the workman was that the ground raised by the workman was that the employer was hostile to him and the workman was likely to be subjected to disciplinary proceedings on the allegation of unauthorized absence. And that therefore the order of reinstatement will have to be modified to be substituted by direction of payment of wages under section 17B of the Industrial Disputes Act 1947 into bracket hereinafter the Industrial Disputes Act bracket over. In the background was the writ petition filed by the appellant employer challenging the judgment and award of the labor court, whereby the workman was directed to be reinstated with back wages. It appears that the petitioner, it appears that the employer's case was, the appellant employer's case was that the workman was reinstated on 29/8/22 when the employer challenged the judgment and award of labor court. The facts were rivally disputed as to whether pursuant to the order of reinstatement, the workman reported for duty or that he was not permitted to resume the duty. Full stop. It appears that order came to be passed on 7/7 paragraph. It appears that order came to be passed by the court by learned single judge on 7/2/22, whereby submission on part of the appellant company was noted that the company was ready to reinstate the respondent into service. Within 2 weeks. It appears that the contempt proceedings were required to be filed, and until 26/8/22, the petitioner management did not reinstate the workman in spite of notices given by the workman. seeking for reporting on duty. Paragraph. Even a bailable warrant was issued, not paragraph, even a bailable warrant was issued against the employer in contempt proceedings. Be as that it may. Next. It appears that the petitioner was subsequently reinstated and was permitted to be joined service from 29/8/22 to 3/9/2022, which was for 6 days. It is the case of the workman that thereafter the management, as appellant herein, did not allow the respondent to discharge the normal duties, and the workman had to make a representation before the management. At this stage, it appears, as observed by, at this stage, as observed by a single judge, management without taking into any other recourse, straightway proceeded to issue notice to the workman, alleging that the workman had committed act of misconduct of remaining unauthorizedly absent by not continuing on the duty. Thus, it is the case of the employer by issuing the so-called notice that the workman remained unauthorizedly absent, whereas according to workman, he was permitted to be on duty only for 6 days, and that the employer was raising a pretext of unauthorized absence against the workman not to continue reinstatement for him. Full stop. It is in these circumstances that the IA was filed seeking substitution of the order of reinstatement, which was passed in course of the proceedings of the petition, with the direction to pay to the workman the wages under Section 17B of the Industrial Disputes Act. Full stop. The fact remains that the reinstatement of the petitioner and his continuance on duty is marred by rival allegations. Full stop. What is the fact which is undisputedly obtained is that the workman is not in service and is not reinstated, rather is not reinstated. Full stop. The petition of the employer against the judgment and award of the labor court is pending. Full stop. The reinstatement of the petitioner is not done amidst the rival allegations as above. Full stop. In that view, and in view of the factum that the petitioner is not in service and is not reinstated during the pendency of the petition filed by the petition, the order passed by on a single judge directing the payment of wages under Section 17B of the Industrial Disputes Act could not be said to be unreasonable or illegal. Full stop. Even otherwise, it is an interim order. Full stop. Section 17B would operate statutorily when the workman is not reinstated and the petition of the employer is pending. Even otherwise, the order is interim order which does not determine the rights of the parties finally. Full stop. This court is not therefore inclined to entertain the appeal. However, while parting, it is observed and expected that a single judge will decide the main petition as early as possible and preferably within 2 months from today.
Lords, I have only one submission to make.
3 months from today.
I have only one submission to make, my lords. There are a couple of citations which I will produce before my lords. Once there is an order of restatement, my
Your
lords,
obligation arises when the workman is not in service. And in the background, there are allegations that you are not permitting him.
no, my lords, that is all incorrect, my lords. What I'm trying to impress upon my lords is this, my lords. When there is an order of reinstatement passed by learned single judge, I have reinstated and she has remained absent. And the final letter which she says is, I am willing to work. She wants to report to the duty. She wants to work. So therefore, when the employer is also willing to reinstate, And the employee is also willing to work, my lords. There is no question of payment of wages, my lord. She cannot sit idle at home and seek wages, my lords. That may not be correct, my lord. Let her come and report to duty.
The operation of section 17B and the payment of wages to the workmen thereunder shall be subject to compliance of the conditions which described in the section, right? You will have to file affidavit that he is not gainfully employed. Correct?
One is that, my lords, but she cannot sit idle at home and derive wages, my lords. She is willing to work. Let her come and report to duty. She herself voluntarily says she is willing to come and work. She is willing for reinstatement. So therefore, there is no qualm at all, my lord. Let her come and report to duty. I am also willing to reinstatement, and there is also an order of reinstatement directing me, and she is also willing to get reinstated and report to duty.
I always said that time and order passed in open court never come back. So that is fine. You can. Time and order passed in open court never come back.
Number 17.
Yes.
Sumana Nagana.
Lord, before my learned senior Lord opens the case, one request, Lord. The order that is impugned before your lordships has outlived its time, and they have withdrawn that order. So my prayer is, my lord, instead of troubling your lordships with the merits of the matter and, my lord, going through the entire maze of facts, my prayer is, in the connected matter, there were about 5 generators, my lord. With one, they have entered into an agreement and paid him the compensation also. This is section 11 case, my lord. So if that compensation is paid to me, I will not, my lord, press, because already the order, the child.
11 of telegraph.
Sorry, my lord.
What is it?
My lord, if I can open my case, my lord.
What is the controversy?
Yes, I think, my lord,
My lord, this section 11 of the Electricity Act, my lord, empowers the state government to issue an order directing that generators within the state should supply within the state. Several petitions were filed questioning the validity of section 11 order. The learned single judge, my lord, allowed those writ petitions and set aside that order. That was challenged in appeal, and your lordships, my lord, have been pleased to consider, after detailed hearing, admitted writ appeal 526 of 24.
That is a offshoot of that.
Yes.
Yeah,
Now,
no.
what happened, my lord, was in that case, your lordships admitted the appeal and granted stay. Now, against the same common order, this is one such appeal which has come up today. There are 3 more appeals, my lord, which relate to from the same order. So, my lord, I request
what
is
I'm-
that this may be, notice may be ordered in this. Is first time this is coming. I'll take notice to them and it may be tagged along with the connected case.
My prayer is, my lord, the other matters are coming up on day after, day after tomorrow, 5th, my lord. Now, pending that, lordships may consider that the order, my lord, passed by them, which was challenged by me before the learned single judge, is withdrawn now. This is, my lord, the order. May I pass it on? The order itself, now, my challenge was to the section 11(1) order of.
Let him withdraw the writ petition.
No, I'll submit, my lord. Pending, what they did was.
Now, whose writ petition?
My writ petition.
My lord,
I
he
challenged
challenged
it.
and
I challenged it.
What did you withdraw?
No, my lord. The government withdrew. I challenged the government order.
Your petition goes.
that's what
That's what I'm submitting. Lord. Now, pending that, what your lordships may consider, kindly see, my lord, the withdrawal order.
Why should we consider anything?
That's what I'm also submitting. In the meantime, Lord, the compensation issue remains. So therefore, what I'm submitting is, I may be relegated to the appropriate commission, that is central commission. I will go and work out my remedies. Unless the issue was, my lord, the compensation. The petition, I challenged the order. During that validity, what rate was fixed by the state government, my lord. Some rate was fixed. They entered into an agreement. Even before the withdrawal, it was in a way withdrawn.
So what was the order under challenge?
Yes, I'll show. The order under challenge is.
Before learned single.
Yes, that is, my lord. 216.
216.
Yes. 219, my apologies. 216 it starts, the operative portion, lordships will get at 219. Now, my lord, this order says this order says, my lord, provisional rate of 4 rupees 86 paise was fixed as provisional rate till the KERC decides the rates. Now, my case was.
Where is that 486?
219, my lord. 219, paragraph 1A, my lord.
Oh, 486.
Yes.
Now, my lord, what happened? Pursuant to this, my lord, 5, 6 of us challenged it. In one generator's case, they entered into a private agreement and paid them some compensation. I am only saying that, my lord, now subsequently what happened, my lord, the order is withdrawn. Even before the withdrawal of the order, may I pass it on, my lord, the withdrawal order? This is, my lord, the withdrawal order.
So can I have a copy, sir?
Yes.
Not allowing me to make any submission.
I am only answering Lordship's contentions. No, instead of troubling your Lordships with the entire case, I'm only
What
submitting.
makes you think that I won't make all these submissions,
No, no.
Mr. Prabhu?
No, I'm sorry, my lord, I will not interject henceforth. I'll just show. That is all. Withdrawal order, my lord. From there, my lord, we can start the.
Sir, copy.
Now, yeah. How do you want copy? Lordships makes this order, 219 order.
Nothing remains in your
Yes.
petition.
But compensation remains, my lord. For that period, in the sense, my lord, where I should get a remedy because I have supplied power. They have withdrawn. They constrained me for a particular time. From that date, 219 date, to, my lord, 1st June, I have to, my lord, get the compensation now.
Do not know which remedy you want to pursue, whatever remedy.
Correct. Now, that remedy, my lord, according to learned single judge, is Central Commission. Because they say the appropriate government is central government. Because I am, my lord, I supplied power to a defense establishment. As per the electricity.
Not know in fact any remedy is open or not.
No, my lord, I have to get compensation. Now, in the meantime, Lord,
Under which provision?
yes, under 11.2, my lord.
11.2.
Yes. And if 11.1 order is passed for that period, I have to, they say that all power should be supplied to the state only. Lordships may see, my lord, 11.1. Appropriate government.
May offset the financial.
Yes, yes. So, my lord, kindly see, my lord, second
Will keep
provision.
this remedy open.
Yes. I will anyway, I am only saying, Lord, I'll go to the Central Commission, I'll get the compensation. That's all I'm saying.
You approach, we don't.
No, the single judge says that. Honorable single judge says the appropriate government is central government. If that, my lord, finding is disturbed, then, my lord, where else I go? And secondly, my lord, as per the Electricity Act, I am supplying to a defense establishment. The central government becomes the Central Commission becomes the appropriate commission.
About this, what learned single judge said?
Yes, that is what, my lord, the honorable single judge says, that state government has no power. And the learned single judge quashed the order. Lordships may see, my lord, the operative portion of the learned single judge's order.
With the merit of the order, not your right to approach under subsection.
No, under 11.2, I have a right, my lord. Even if it is, I have a right. If your lordships were to, my lord, dismiss my writ petition or say that it is.
Keep that window open.
Yes. No. Otherwise, I'll argue it on merits and show, my lord, how that order is bad, and let the learned single judge's order may be confirmed. They will not lose anything. I am not arguing against them. I am only saying, Lord, if learned single judge's order is confirmed and I am relegated to Central Commission, even if I am not relegated.
Preferred under Section 4 of the Karnataka High Court Act 1961, this writ appeal is directed against judgment and order of learned single judge dated.
May I make one submission, Lord, before that? If I am again.
11th March, let me complete sentence.
I'm sorry. I'm so sorry.
Neither he allows me or your lordships.
No. I am
Article 14 is
I'm not
applied.
troubling.
by
I'm
Mr. Prabhu.
sparing both of you from the
Before
trouble.
we can say one word, my lord, he is saying something. Before your lordships can start.
Sparing, Lord, the time and, my lord, the effort.
Yes,
I am myself saying the order is withdrawn. I will go to the Central Commission.
Listen to the order. If anything.
Even one more submission, Lord. One generator has already, my lord, got the compensation from them under an agreement. Under that, your lordships may ask me, same rate may be paid. I will not even relegation. No, one generator they have on parity, my lord. One generator was before this honorable court, before the learned single judge. They, my lord, paid the compensation. He withdrew his claim. Lordships may see the impugned order itself.
This case has come up for admission today, my lord. Let us not, my lord, take your lordship's valuable time, my lord. An appeal against the same common order is admitted and it's ordered to be listed before the court.
But there is substratum has gone. Very challenge is withdrawn.
No, my lord, what I'm saying, if he's withdrawing the writ petition, my lord, I have no difficulty.
No.
But one.
I will not withdraw the writ petition, and writ petition, Lord, need not be disturbed. All that I am praying is, with one generator, you have signed an agreement.
What is the prayer in the writ petition?
Yes. Writ petition is, my lord. Lordships may see. Writ petition.
The last.
215, I think.
Yes.
212.
Yes.
Page 212.
212, my lord. Issue a writ of certiorari. Kindly see, my lord, A. Issue a writ of certiorari, any other writ notified in so and so. That order, my lord, that I showed, that order is sought to be quashed. Then writ of certiorari to quash the impugned communication bearing this SLDC's communication where they stopped me from exporting power out. Now kindly see C, my lord, prayer C. This, my lord, was the prayer. Direct respondent CRC to determine the damages to be paid due to illegally denying open access from so and so date to so and so date at the cost of 1% per month. Now, my lord, so this survives because, my lord, for that period they restrained me. Whether validity is there. Now, second submission is even before your lordships get into this issue, my lord, already with other generator who's challenged the same writ petition, he was given money. He was not even asked to go to CRC. They, my lord, entered into an agreement and paid money. And he is happy. So same money may be asked to be paid to me. All issues may be, my lord.
So you are saying that after the setting aside or withdrawal of the order 1610,
Yes.
this pair survives?
Yes. Because I have to get the compensation for that restrained period. Yes.
Your remedy is under section 11.2.
Yes.
That much you have submitted.
Yes.
That I now slide down.
Only question, my lord, would be, one of the issues that arose before the learned single judge was, this 11.2 power, my lord, we have already moved the Karnataka State Commission for fixing the rate. My learned friend says he doesn't want to go to State Commission, he wants to go to Central Commission.
Not saying anything.
Yeah.
We are only saying that we are not damaging his case nor writing anything against you. We will say that remedy is open under section 11.2.
But if that is said, my lord, then I will be, then, my lord, this commission will not enter my application because I am a central, my appropriate commission is central commission.
We are not going
No,
to.
then, my lord, it may need to be decided on merits because who is the appropriate commission is the very issue involved. Otherwise, my lord, that issue will not get settled. If I go to the state commission, my lord, the state commission has no, for other generators, he may have. He has filed an application. State commission is appropriate commission in 90% of the cases that let it get decided, my lord. For me,
there is a dispute as to who is the proper.
yes, that is the issue, my lord. If your lordships were to just keep that issue also open.
In that interim order, we also have made some observations.
Yes, made some observations, my lord. May I persuade your lordships to see the interim order in the other matter?
Other matter.
Yes. May I pass it?
That observations are probably against you.
No. The lordship said that in energy watchdog's case, the central commission is held to be the appropriate commission in interstate supplies. And this was sought to be distinguished by learned Lord Senior. Therefore, my lord, the whole crux is which is the appropriate commission to which I should go and get the compensation.
So
that issue remains.
We may issue notice and keep it.
That's what I'm submitting.
It is day after
Because
tomorrow.
if they are saying that sustain a portion of the order, I am aggrieved by it, my lord, I'll argue my case.
No, one generator, they pay money and he's satisfied, my lord. Other set of generators, they have filed application in KERC.
Only thing is that if we tag this with the other petition,
yes,
your remedy to get compensation will be delayed. We have no objection.
No, I am only saying, my lord, what prevents him? If your lordships were to say CRC is the, if I go to CRC, my lord, how will they be affected? That's what I'm saying.
Under section 4 of the Karnataka High Court Act 1961, the challenge in this writ appeal is addressed by original respondent, State Lord Dispatch Center, to judgment and order dated so and so, whereby the petition is of learned single judge, whereby petitions are allowed, and order of the state government dated 16/10/23. Insofar as the order extends to those engaged in the interstate transmission of electricity and the following and the consequential withdrawal of the approval objections, came to be set aside. Came to be set aside with consequential withdrawal of approval. Full stop. When the appeal comes up for consideration, it was stated, now, not that. In the main appeal, following prayers are made. Page 212, this green flap. Bracketed portion, Roman 1, 2, 3. To quash state grid. To quash SLDC, and C, to direct. Number two, Central Electric Authority, to do so and so, at 1% per month.
Your name
Three.
and-
Full stop. The first prayer in small Roman 1 is the principal prayer, whereas the other two prayers are consequential. Full stop. Prayer 2, small Roman, prayer 3, small Roman 3, regarding giving direction to the second respondent, Central Electricity Regulatory Commission, to determine the damages to be paid on account of illegally denying open access for the period from 17th October 23 till date of resumption of the open access, is the prayer dependent upon the first principal prayer paragraph. When the appeal came up for consideration today, comma, learned advocate to respondent, original petitioner stated that now the competent authority has withdrawn the order dated 16/10/23, which was impugned in the petition and which was set aside by learned single judge. Full stop. When the impugned order itself is withdrawn, comma, neither anything survives in the writ petition, nothing survives in the present appeal as such, since the subject matter has become infectious. Full stop. The appeal could have been disposed of, the writ petition, by issuing appropriate direction, which may be necessary to be issued incidentally, more particularly in the context of prayer Roman small 2, here in above paragraph. Learned advocate paragraph for the respondent, however, at this stage submitted that though the respondent petitioner has a remedy under section 11 into bracket small 2, regular 2 of the Electricity Act of so and so, which is the year
So 2003.
2002, comma,
Three.
since
Three.
there is a dispute as to which is the competent
The Central
law
Commission.
to determine the question of damages, comma, the present subject matter dispute survives to that extent. Full stop. It was further submitted by both the councils that similar issue has been under consideration by this court, in which matter
5, that is, my lord, I passed on.
Writ appeal number 526.
526 of.
That is, my lord, traders case. There also.
There are 3 cases pending, ma'am.
In the aforesaid view and in view of the aforesaid scenario emerging, there shall be notice to the respondents returnable on to be listed,
It is day after tomorrow, my lord.
to be heard with writ appeal number
Yes.
526/24.
Yes.
My lord, in this case, notice, my lord, may be dispensed to respondents 3, 4, 6, and 7. They were not appearing before the learned single judgment.
No, but still
Page 6, my lord, is a cost title. 3 is the Central Commission. They did not appear. 4 is the
So notice to home.
3, 4, 6, and 7.
No, they were let there be representation, my lord, because Central Commission, I have asked for compensation. If they are not there, they will say, my lord, it is not binding.
4, 6, and 7 for the present.
Sorry, my lord.
For the present.
Yes.
Please.
So it will be listed day after tomorrow.
Great.
If possible, we'll dispose of. We don't-
Grateful. Great. Would it be at 2:30?
I given
Because
the 2 connected cases.
Hundreds of generators are waiting, and our sugarcane producers and, my lord, the people who are dependent on them are, my
Let's see
lord.
what happens on 5th.
Lord, I given the connected 2 other cases, my lord, identical from same order. They also may be ordered to be listed. I given the numbers.
The state also is in appeal.
Sorry.
Any date is given in those orders, those cases?
No, they have not come up at all, my lord.
Then list.
2 more new cases which have not yet been listed. They may come up.
I'm on caveat in these matters, not served. Anyways.
Huh?
Great.
Bill number 18. Chandrasekhar L.
The state had to come up with the scheme. This is a
the-
case where the panchayat was free to give the neighboring land in excess while giving the plan sanction.
Other petitions are admitted at this point.
My lords?
My lord, this is a case, my lord, where adjoining neighbors, my lord, according to, my lord, the appellant, my lord, there is a road between the two properties. My lord had called upon me to produce, my lord, the notification under which the assistant commissioner had passed an order of conversion. My lord, I have received it yesterday. If my lord could have it after 1 week, my lord, I'll file it along with the memo.
18th it may be posted. 18th.
Obliged.
Obliged.
My lord, submission.
My lords, kindly.
Tomorrow, my lord,
The next matter, may I seek for a week's time, my lord? Serial number 19.
Residential house, my lord.
1 week, my lord.
18.
Please.
My lord, residential house, my lordship. My lordship.
Court officer, court officer.
ಹೇಳಿ ಹೇಳಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ವಿಡಿಯೋ ಆಫ್ ಇದೆ.
ವಿಡಿಯೋ ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ಆನ್ ಆಗುತ್ತೆ ಮೇಡಮ್. ಇನ್ನು
ನಂದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಅದಕ್ಕೆ.
ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ಆನ್ ಆಗುತ್ತೆ.
ಆಯ್ತು, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.
my lord, at 2:30, my matter, my lord, item 74 is listed, my lord. Your lordship on the last date of hearing asked me to make a mention. Since I have come from Delhi, my lord, so therefore I'm making a mention, my lord.
With my lord's permission.
With serial number 71, my lords, where my lords here is appearing. My lords, today there is some bereavement in their family, my lord. Could it be taken up on next week, my lords, at 2:30, my lord? Where my lords, senior counsel has complained, my lords, he has commenced his arguments.
That cancellation of plot.
Yes, my lord.
It will go which date?
Not 10th, my lords, at 2:30, my lord. Or else any Wednesday, my lord. Or else any Wednesday, my lord. Yes.
Tenth may not be possible.
Yes, my lord.
My lords can take it on 17th, my lords.
24th.
But could it be on 17th, my lords?
17 is holiday.
17th holidays.
Oh,
Much of
With
24th.
at 2:30, my lord.
We'll take up.
serial number 30, please, my lords. Serial number
65 days. Final hearing. The matter pertained to the National Highway collection of toll. Constitutional variety of the provisions have been challenged. Section 8A, which has been amended under the National Highway Authority. Because subsequently in 2000, Central Road Fund Act has been formatted. Based on that, now they are collecting diesel and petrol cess and other various. Now it has, as of today, it is about 15,000 crores. So 95 Act, when it was amendment has taken place, that is not replaced under the 2000 Act. So because the matter is very urgent, because every day now toll charges have been increased every place. And maintenance of road is also not there, and committee, your lordship, on 12th September 2023, it's an order passed by this court to seek response to the memo filed by me. Till date, the Union of India has not filed their objection to that. But the CAG has observed if there is, committee has to be constituted on the Highways Act, your lordship. Till date, no committee has been constituted.
18th.
So because you will not any candidate at 2:30, you will not make.
18th. Advance date. Yes.
serial number 30, please, my lords.
Serial number
30.
30.
30. Has been instructed.
What do you want?
Instructed that the accused are complying with the order. 18th, it may be fixed, my lords. They said they will. There's an inconvenience on my part to appear.
It is complied with then?
It's a CCC. They will comply in 18th. That's what they have stated. I'm seeking time because I have some personal inconvenience, my lords. I had to attend the medical procedure.
30.
30, please, my lords.
18.
Please, my lords.
Lordships kindly, my lord, the serial number 72. I need a week's time, my lord, in this. I'll file my counter to the affidavit, what they have filed. 72. I need a week's time. I have to furnish translated copies and all.
18th.
Please.
Serial number 33.
Serial number 12.
33.
I appear for the accused. The order of the single judge has duly been complied with, Your Honor, and the contempt does not survive for consideration.
33, learned advocate Mr. Satish K.
Is the appellant. I for the response.
States that the order under contempt is complied with. The compliance is confirmed by learned advocate Mr.
I appear for the accused, A. Chandrachud.
For respondent, so and so, for respondent. In that view, since the order is complied with, the contempt petition no longer survives, it is accordingly disposed of.
Duly obliged.
Serial number 12, my lordships. Serial number 12, my lordships.
Appeal number 1.
Your Lordship,
This is notified because is it same as the other? Is it same as 469?
same, Your Lordship.
The prayer is different. You were given notice about the misconduct 4 years back.
4 years back. Your Lordship, my senior has got some inconvenience, therefore he could not come today.
This is small thing you could have prepared yourself.
We are not aware what is,
You must be apprised yourself about what is the matter. Tomorrow you come tomorrow,
Okay,
not
sir.
beyond tomorrow. You read the papers, you find out what is the issue. Any difference is there between the appeal number 469 or 23 and this appeal? Because in 469 order is already passed and disposed of.
Obliged, Your Lordship.
Only since there was some doubt whether about this is similar or not, it is notified tomorrow at 11.
Appeal number 3, Mr. Vasant Kumar HT.
Notice returnable on 6th of August. You don't want notice?
Pardon me?
You want or not? You want notice?
Yes, my lord.
Given.
Please. Nothing.
Appeal number 7. Mr. Kiran BS.
My lords, this matter relates to the imposition of a penalty under Section 20 of the RTI Act. My lords, my submission is that I was not the designated PIO to begin with. My assistance was sought on a certain application, which I provided.
Who was PIO?
PIO was R3 in this appeal, my lord. The director of the institute for the matter, and the notification to that effect is in Annexure F. Page 71 is the English translation.
So how the learned single dealt with that aspect?
My lords, in the impugned order,
Argument is more nature of technique.
on page 29, my lords, he's held that I have furnished the information. My role was to assist the PIO under Section 5, subsection 4, which I've complied with within a week's time. And then, of course, the learned judge in paragraph 9 and also paragraph 8 goes on to observe that I'm hiding behind technicalities. It's neither trivialities nor technicalities that I'm hiding behind. It's only the applicable provisions.
So at the point of time when the information was asked for, you acted as PIO?
I did not, my lords. I just assisted the PIO, providing the relevant information to the PIO to be passed on to the applicant. So under Section 20, the imposition of penalty cannot be against an officer who has assisted the PIO. Because it so happened, my lords, that the designated PIO did not pass on the information to the applicant.
Did they file the statement of objections in your petition?
In the appeal, in the writ petition, they did not file their objections.
Now let us see your petition. What is your case?
My case is that, my lords,
What are the averment that you assisted?
in the petition, my lords, or in the appeal?
Petition.
Petition, yes, my lords. My lords,
To the second appeal. Order and a challenge before single.
that is in Annexure A of the writ petition.
Yes.
Second appeal. So two appeals went against you.
Yes, my lords.
So what is the finding of fact? Let us see in the appeal.
Yes, my lords. The order of the second appellate authority
is on page number 52 of the memorandum of appeal. It's in Kannada. The English translation is on page, it starts with page 58. My lords, on page number 75 of the appeal, my internal memo copy is there. The application itself is dated 15 March 2013. So internally, my assistance was sought for providing the information to the designated PIO. And that I have provided on page number 74. The translation is on 75.
Who is PIO according to number 3?
Respondent number 3, my lords. Respondent number 5 is the public information officer. She sought information from me, assistance for responding to the application, which I've provided.
You are number 5, respondent number 5.
No, I'm the appellant. I'm the petitioner in the writ proceedings.
Petitioner in the writ. Who was respondent number 5?
Respondent number 5 was the public relations officer of the institute. Respondent 6 is the applicant.
Let us see section 20 in the RTA. So where is the order imposing penalty?
That's in the writ petition. That's there on page number
25,000. Where is that?
Yes, my lords. Page number 29 is the number 7, paragraph 7, 8, and 9 are the relevant paragraphs.
No. Original order.
Originally, it is on page 52. That is the second appellate authority's order. 58.
Page?
62, paragraph 19.
Who is, you are Dr. C. Ramesh?
Yes, my lords. Dr. Ramesh.
Shall we take up on 8th?
My lord, can I make one submission?
You are the only party.
No, my lord, the other respondents are there, my lord. The Karnataka Information Commission Director and Principal Secretary, Principal Kidwai Medical Institute of Oncology. My lord, paragraph 4 of the writ petition may be seen for a minute, my lord. My lord, paragraph 4 of the writ petition, my lord. Yes. Page 38, that clinches the issue. My lord, it's under that he has been,
By a superior. Actually, it was a colleague because both of us were at the same level. I was not the public information officer. That was R4, my lord, R5, my lords. Under the notification, it is R3. But since de facto R5 took upon herself to furnish the information, she became de facto PIO in the matter. Number 5. Yes, my lords. No, my lords. The notification to the effect under section 5, subsection. Yes, my lords. Respondent number 3 is the one. Yes, my lords. Yes, my lords. Number 5, yes, my lords. Yes, my lords. It is there on page number 75. It's annexure H. It's the English translation. The application. No, my lords, it was an oral check for assistance, request for assistance. This is the one, my lords. This annexure H is the official correspondence, and it has been duly attested. It is in the file of the institute. This is the document, my lords. This has been duly attested by the administrative officer. This is a certified copy. I'm the PG coordinator. HOD academic cell is the director. He was the public information. Number 3. Yes, my lords. Yes, my lords. Yes, my lords. That's the Department of Epidemiology and Statistics, not the academic cell. Not the academic cell. I was only the coordinator for the academic cell. During the course of proceedings, it was supplied. Yes, my lords, because that also is information. I mean, in the file, there were the grievance of the applicant. Yes, my lords, because yes, my lords, because reason being the grievance, the applicant had filed an application seeking action taken report. There was no action taken report, and there was nothing in the file, and that is what I furnished. Yes, my lords. Obliged, my lord. No, there's a 2-day delay, my lords. My leg was fractured. Six weeks I'd been advised bed rest, my lords. Obliged, my lords.
Okay. Yes. Seal number 12. Mr. Kumar Swamy.
For petitioners, my lords. And for petitioners, my lordships. I'm for petitioner, my lordships. There is a delay of 61 days in presenting this writ appeal, my lordships.
Yes, argue your case.
My lordships, I pray for 1 week time so that I can personally appear before the court and submit my arguments, my
Time
lordships.
cannot be given.
Okay, my lordships. Yeah, in this this repetition is filed against the impugned order passed in repetition number 24/900/2022, my lordships,
Nothing,
wherein
nothing. There is nothing in your appeal. Sorry, dismissed. You filed second petition after dismissal of the earlier petition on same cause of action, on same issue. So learner single rightly relied on Supreme Court judgment to dismiss your petition.
but my lordships, here the petitioner is not the same, my lordships.
Maybe.
In earlier petition, the similar petitioners are not there, my lordships.
Your proxy.
The earlier petition filed, they were not the exact petitioners of the legal heirs of the present petitioner, my lordships.
Sorry, come with the better matter. Dismissed.
Seal number 68. For withdrawal, Mr. Mohammed Tahir.
Day after tomorrow.
Number 69.
My lord, in this matter, my lord, may seek your
Kumar,
lordship's indulgence, my lord, we preferred an appeal against this order, my lord, order of the learned single judge. Writ appeal 833 of 2024. May I request your lordships to kindly grant me a permission to present my case, my lord.
What do you want?
Lord, we preferred an writ appeal against this order of the learned single judge, my lord.
Who has referred?
English, my lord.
Other side?
We have preferred, my lord, the,
You are for respondent.
I appeal for the respondent.
Ah,
Sorry, my lord. Sorry, my lord. We were the corporation has
Yes.
preferred an appeal, my lord.
Writ appeal is preferred.
Payment is not yet made. Payment is not yet made.
Writ appeal is preferred.
Writ appeal have not available. So far, we have not
They are
received any
saying.
copy.
833 of 2024, my lord.
Number is also given.
We have not received any copy. So
That is different. To be listed with
833 of 2024, my lord.
so and so, so and so. And copy of the writ appeal to be given to
69.
learned counsel. Your senior counsel,
no,
your senior counsel. Your senior counsel,
I'm the only counsel. Yes.
senior counsel. Give copy to senior
Please.
counsel.
Seal number 70. Mr. Aniruddhar Nayak.
They haven't given. Yes.
My lords, this petition
impugns annexure H and H1 at
Why it is kept at 230?
Let's make the submission.
for disposal, my lords, because what has now happened, if I may just recount the facts a bit and then come to what they have filed so that the entire context my lords will get. My lords, a notice for proposed direction was issued by the Pollution Control Board to me. They pointed out about 13 infractions committed by me on their visit to my factory premises. I have 2 units, Unit 1 and Unit 2. Now, in respect of those violations, I submitted my responses and I told them that out of 13, 8 have been complied with. Now, by February 2024, I had complied with almost all of them, and I submitted a report also was submitted by the Assistant Environmental Officer. Thereafter, despite this submission of the Assistant Environmental Officer's report, a personal hearing was called upon and a decision was taken to close my unit. Now, that is what I'm against before my lords. Now, on the last occasion, my learned friend had handed over a memo with a direction. If my lords could just take that memo, my lords. Date till, but filed by them on just last week. At page number 17 thereof.
17.
My lords have that memo filed by them, the other side, the Pollution Control Board, page number 17. If my lords see serial number 15 and 16 at the fag end and at the extreme right-hand side, if my lords see that, recommended to defer for further discussion and call for industry. So now, my lords, in our petition, all we were seeking was that the AEO's report be considered and orders be passed. So now that the decision has been deferred, my lords may send the matter back, ask them to take cognizance of that report and then pass orders in accordance with law. That's all my request is.
Who has recommended to defer the matter?
That's it's a committee, state level enforcement committee, methods, which has been constituted, methods. And that's when we had a look at the entire matter. The
So
committee,
it can be done or not?
it can be done, methods. All we have asked him is come and give us another presentation on the technical aspects. And whatever recommendation which the previous chairman has gone ahead and proposed to close down the industry, methods, we've said we'll keep it at abeyance. You come and give us a technical presentation and we will take it forward. At page 17 of my memo, methods, which I have submitted on 20th of last month. That's in view of this memo, methods, it can simply be disposed of without any direction, methods. So whatever they want, let them go and submit.
No, my lords,
If they have something more to it, if they have something more to it,
I'm sorry.
first and foremost, methods, they have challenged.
This page 17 is part of what? Some minutes?
Yes,
It's a part of the minutes.
It's a part of a committee meeting, my lords, and the minutes of meeting are produced before my lords. So it's an advantage of the petitioner itself.
No, if my lords see annexure H and H1,
that we have kept in abeyance now.
There's already a decision to close my unit. So unless that goes, considering anything else without that being set aside is pointless. Because the AEO's report very clearly says that I am in compliance with all the alleged violations. So my only request is let them take cognizance of that also. Give me another opportunity, I will go. Let them pass orders in accordance with law. That's all my request is.
You complicated, man.
Fair enough. What is wrong?
That's we are only saying that we have given them an opportunity to come and give a technical presentation. Now, that's setting aside of the personal hearing meetings may not arise because the
We are not
cost.
setting aside anything.
Yes, we'll take care of it.
We are not setting aside anything. Fresh decision.
Let them take a fresh
After
decision.
considering your.
And the AEO's report at annex.
Who's assistant?
Environmental Officer's report at annexure E and E1.
And they have to come, alerts, and give a technical presentation.
We'll do that.
That's what we've called them for. There they can produce any documents they want.
What is that units?
What is a unit?
Industrial unit.
Industry is into manufacture of sponge iron.
So this concern unit 2 only.
Unit 1 and Unit 2 both.
Both.
Both. H1, H and H1, both are impugned. And E and E1 are the reports for the respective units.
Heard learned advocate Mr. So and so, Anirudh Nayak
Anirudh Nayak,
for the petitioner and learned advocate Mr. Chaudhary.
Mahesh Chaudhary.
Mahesh Chaudhary for the respondent pollution board. Whereas learned government advocate Mr. Mahendra appeared for the respondent state of Karnataka and its authorities. Full stop. The case of the petition is that the petitioner runs 2 industrial units. Unit number 1, Roman capital 1 and unit number 2. It appears that certain violations were alleged in respect of functioning of the units of the petitioner under the environmental law. Full stop. The officer of the pollution control board visited the factory premises of the petitioner to inspect the violations. Full stop. The notice was also issued to the petitioner, which was replied to. Full stop. Thereafter, thereafter a personal hearing was given to the petitioner. Paragraph. It is the case of the petitioner that at the stage of personal hearing, all the alleged violations were complied with, and the deficiencies in law, which were pointed out by the pollution control board, were made good, were met with. It was submitted that there has been a report by the assistant environment officer, which fortifies that the petitioner has cured all deficiencies. Wherever it is on this premise of factual pleading that the petitioner prayed to your units are closed.
No,
It's functioning.
It's functioning. There
So-
was a proposal. If my lord see
So the cause
annexure,
of action to file petition.
annexure H,
Proposal.
annexure H, if my lords may
Proposal
see.
to
Propose, it
No, no,
was
no.
a recommendation, my lords, to close.
No,
My
no,
lords
no,
may look
no,
at
I'm
page
sorry, I'm
77.
sorry.
One second. My lords may look at page 77 for a moment. In the middle quadrant, my lords, from the bottom, second paragraph, from the bottom. Page 77 of the writ petition. That's from the bottom, my lords. Shri Anand Shwaf, CEO of the industry, attended the personal meeting and submitted compliance report. Further, he informed that he has taken measures for implementing pollution control measures, such as all raw materials are covered with the tolerance, so and so and so. Well, that's the last 2 lines. He requested the board for some more time for implementing all conditions and complete compliance to 13 points evolved for sponge iron unit to mitigate dust pollution. And in the, and let's turn to the next
you
page.
propose to close the.
We pl-
78.
It was a
Page number
proposal.
78, if my lords takes a look. After detailed deliberation, presiding officer
No,
issued
no.
the following directions.
We only want to know what is the cause of your grievance.
It's a proposal.
Proposal.
No, it's not a proposal,
It
man.
is a proposal.
My lords, presiding officer issued the following directions.
As against the above case of the petitioner, it was pointed out by learned advocate for the pollution control board from the meetings of the
Personal hearing.
proceedings of the personal hearing meeting that the representative who attended the meeting requested the board to grant some time for implementing the conditions and complete the compliance of 13 points evolved for sponge iron units to mitigate the dust pollution. It was therefore submitted that the compliance was yet to be done by the petitioner and certain steps were taken in that regard. It was in that view, it was submitted that the proposal was mooted for closure of the units of the petitioner. Full stop.
If I'm very sorry, my lords. If my lord sees 78,
We are not damaging your case.
all
Kindly listen.
grateful,
Full stop.
grateful.
While the controversy stands with above rival case, a decisive feature is noted from the record, as pointed out by learned advocate of the petitioner. The minutes of the state level enforcement committee held on 12/6/24. The copy of the proceedings which figure on the record of the petition, indicate that The petitioner, Vanya Steel Private Limited. The case of the petitioners, two cases of the petitioners, the cases of two units of the petitioners. Vanya Steel Private Limited, Unit 1, and Vanya Steel Private Limited, Unit 2, have been recommended by the board for deferring the decision. Full stop. What is recorded was that, comma, inverted comma, recommended to defer for further discussion and call for industry for technical presentation before state level. What is that?
Enforcement Committee.
Enforcement Committee, interpreted SLEC. Full stop. The specific case of the petitioner forthcoming in the petition and in course of the hearing is that all the deficiencies are, all the infractions are complied with, and the report of Assistant Environment Officer of the Pollution Control Board stands in fortification. Full stop. When the decision on the case of the petitioner is deferred as above by the board itself, comma, the following directions will met the interest of justice. 1. The petitioner shall appear before the SLEC on the date which may be fixed. 2. Petitioner is permitted to submit in support of his case and rely on the report of the Assistant Environment Officer. Number 3. If any deficiency is yet to be cured, it may be cured by the petitioner before the date of appearance before the court. If by that date, for some reason, the deficiencies are not cured, the board shall give further time to the petitioner to cure the deficiencies.
That's this proceedings.
What is wrong in it?
Please, minutes, I reviewed.
Sir, full stop.
These are categories of industries, my lords, where from 2nd of May 2024.
It is only after the aforesaid exercise that the final decision will be taken by the respondent pollution board. With aforesaid observation and direction, the petition is disposed.
Deeply perplexed.
My lords, may I request, my lords, for curing the defects, let the time limit be fixed, my lords.
It is for you to fix.
71, 72 urgent, number 73, Mr. Subramania Patyam.
For the complainant, my lord.
Yesterday's met.
Yes, Lord.
You already from the place.
What is the direction?
Compliance is done, my lord.
Done.
Yes, your lord.
Learned advocate, Miss. What is the
Rashmi
good
K.
name?
Rashmi.
So and so for the complainant stated that the order under contempt is complied with. The full stop, not the learned additional government advocate, Mr. Mohammed Jafar, for the respondent produces memo dated 29/6/24. Paragraph. The memo reads as under paragraph. As could be noticed after quoting the memo, as could be noticed, comma, the order passed by the Divisional Secretary, Department of School Education is produced, which marks the compliance of the directions of learner single judge. The contempt proceedings are liable to be closed accordingly. They are closed as not surviving. So this is 70.
73.
3. Yes. Any other matter? Yes, next. Continue.
74.
Please. 74. Why?
74.2, my lords, I represent the appellants.
What is the matter?
My lords, the issue is of disturbing the seniority list.
No, this will take place.
It has to be heard, my lords,
It
later.
has to be heard. It is not a 2:30 minute.
No, last
That's
time
a-
it was fixed at 2:30, my lord. I had made a request, my lord, and since I am coming from Delhi, my lord, your lordship has specifically fixed at 2:30, my lord.
You are welcome from Delhi, but to an extent we will not be able to accommodate at the cost of others. You are making it a very, all councils from outside will be
No, my lord,
accommodated.
I am making a request, my lord, I am not.
Today it will take time, so kindly come another day and we'll fix at 2:30.
Since it was,
Seniority can wait, Mr.
please, my lord.
Seniority issue can wait. What has
The
happened?
list
was
which is
that-
very,
Because this will take at least 1 hour. It appears.
little more, my lords.
No, they have to
Little
point-
more than that,
No,
because
no, no.
KPTCL also has filed an appeal. That's, my lord.
There is a common judgment, my lord, they have to point it out, where is the error in the judgment of the learned single judge.
My lords, I appear for the corporation in the matter, my lords.
It's in the council has come for some time. We
Obliged,
now
my lord.
at least understand the controversy.
You shuru ಮಾಡ್ತೀರಾ ಏನು?
My lords, I appear for the corporation, my lords.
Why you are not available physically?
No, my lords, I'll be present, my lords, if my lords, in 15 minutes I can reach, my lords, because the matter was taken up. Yes, ma'am.
It is your appeal.
My appeal, my lords, is there in 1211/2023, my lords.
Lords, basically the issue related to, my lords, the seniority list prepared of the assistant engineers. From the year 2000.
Lords, for my lord's convenience, my lords, the synopsis is also.
ಸುಬ್ರಹ್ಮಣ್ಯ, ನಮ್ಮ ಹತ್ರನೂ ಇದೆ, ಕೊಡೋಣ. ಇದೇ ಮಾಡಿದೀವಿ. ಕೊಡಿ.
It's factual aspect.
Your synopsis, we have filed, no? Lords, we in 74.2, my lords, we have filed the synopsis to the court. Brief synopsis has already been filed.
So, what is your good name?
Sir.
You are for original petition.
Yes, my lord.
What is your good name?
Kumar Parimal, my lord.
Kumar
Parimal, Parimal.
Parimal.
Please, my lord.
Really. 427 of 23. ಹಾಕಿದ್ದೀರಾ? ನನ್ನ ಹತ್ರ ಇದೆ ಅಲ್ಲಿ. Lords, I will be referring from 74.2,
Yes.
which synopsis has been filed. ಕೂರ್ತೀರಾ ರಮೇಶ್? ನೀವು ಒಂದೇ ಕೊಡಿ. I'll be.
Where is annexure Q? Mister, annexure Q in the main petition, which was under challenge, which is that?
Page 348.
Endorsement.
348 second word.
In writ appeal, my lords, 423 of 2003.
5320.
Second one. You will put anyway. I'm referring to writ appeal 427 or 23. In that it's at page 426, annexure Q.
So
Please
not, you're not so lucky because papers are not, they are not received. Volumes are not received. Yes, let us see what is the case.
Lords, it's like this. Lords, this relates to seniority of assistant engineers, my lords, of KPTCL, that's Karnataka Power Transmission Company Limited. Lords, the genesis goes to, my lords, we have filed synopsis. Lords, in the ABT, appointment by council.
Page 69.
So board order dated 27/12/96.
Yes.
Provided that if the transferee engineers had completed 7 years,
That's yes. No,
that weightage can be given.
that is 27/12/96.
There you want to follow that circular?
No, my lord, so far as we are concerned, that, my lords, was the difference. My lords, I'll just, 3 dates I'll say. The first circular of transfer under the rules of KPTCL, government rules, my lords, was on 25/7/1986, which provided for, my lords, appointment by transfer of junior engineers to the cadre of assistant engineers.
Yeah.
It provided 2 things, my lords. One is the effective date was date of graduation. My lords, the condition was the junior engineers had to pass a qualifying examinations. So it provided, to provide seniority or consideration for seniority, it provided date of graduation will be taken into consideration.
Before you proceed further, the crux of the matter is this, or that they want the seniority list to be upset after 20 years?
That is the issue. From, my lords, after 20 years, from 2000, this list has been in existence. Lord, what they do is innocuously after Pavitra 1, BK Pavitra's judgment, which comes in, my lord, that was only relating to the reservations. They give a representation to KPTCL saying that the reservation seniority has to be redone. My lords, the mandamus, simple mandamus is issued, consider their representation. Based on that, my lords, they now claim that the seniority list existence from 2000, where many of them have retired and gone.
Correct.
That has to be disturbed. Now, my lord, the learned single judge holds delay and latches will not come in the way. Our case is from 2000, based on these circulars, based on the judgments of this court, that the seniority list was prepared and they never questioned it. In 2000, when the seniority list came, they never questioned it.
So many more must have been given promotion also.
Promotion, many are retired also.
Retired apart.
Retired and go.
Promotions also.
Yes, it's all done. Seniority, my lords, 2000 seniority list was the first time after all these circulars and, my lords, orders which came.
You are right on that score, then nothing is to be gone into.
Nothing should be gone. Now, my lords, that's what our case. And for the first time, they filed representation, 3 of them, only in 2017.
Yes.
Lords, that
between 96 and 17, 21 years have passed.
nothing has happened. They keep quiet. And subject to correction, I think one of the appellants has also retired. They also got.
This is
So
only
this issue has to be gone into.
broad consideration.
My lord, the learned single judge had dealt with the issue of delay and latches, my lord. In 2017, for the first time, we came to know that how these ABT engineers were appointed, my lord. Before that, we never came to know, my lord, all these things, my lord. And for the first time in 2017, in BK Pavitra 1, my lord, the provisional seniority list was published, my lord. And for the first time, the KPTCL, my lord, published the provisional seniority list indicating the source of appointment, my lord, how they came into the service, my lord. And earlier, they were only showing assistant engineer, not how they came into, they were recruited as assistant engineer, because initially they were junior engineers. So 2017, first time we came to know, my lord. Therefore, the learned single judge in a very elaborate manner.
Merely because you come to know in 17.
Please, my lord.
That by itself will not a ground to unsettle the settled thing.
No, no, my lord. The learned single judge, I will show, my lord, the learned single judge has dealt with the issue of delay and latches, my lord. That 89 ABT engineers were there. Some of them retired, my lord. So not a large number of persons are there.
There are judgments about the unsettling of seniority.
Yes,
after.
Lord, there we have the compilation. We'll produce.
There-
Lords, this requires, if they have waited 17 years for a seniority list, my lords, to challenge.
Lords, time up, you have to get out from this aspect first.
My lord. I will demonstrate, my lord. I will demonstrate, my lord.
I am
Lords,
only saying, my lord,
only one
17 years they
submission.
waited. Today to plead, there is extreme urgency. We do not find that kind of 17 years they waited for a seniority list which was in
We
existence.
have taken up the matter, but now you, in the next hearing, you focus on this aspect.
Please, my lord.
Lords,
Recently-
only one submission, Lords. Only one submission, Lords. This is a case where, Lords, there was a challenge, Lords, to the 1986, Lords, rules itself. Lords, later on, Lords, this honorable court, Lords, relying upon the decision of the honorable Supreme Court, Lords, in the K. Narayanan's case. Lords, that circular, Lords, was set aside. Lords, thereafter, Lords, they were supposed to implement, Lords, the order of this honorable court. Lords, they implemented it. They accepted, Lords, from 2000. But however, Lords, they refused to, Lords, implement the very same order, Lords, from 1986. For the reason, Lords, what they have given a Tanakshar Q, Lords, is that it would upset, Lords.
Let us see this aspect of delays, how dealt with by
Lords.
Lansing.
There were two, one second, my lord.
Very long
There
judgment.
two judgments,
lord.
there were two judgments of the Supreme Court, my lord. The K. Narayan judgment, my lord, and Sudhakar Rao judgment, my lord. So in view of the K. Narayan judgment, my lord, the division bench of this honorable court in Guru Sripa's judgment asked them, the KPTCL, to follow K. Narayan judgment, my lord. Which, and this Guru Sripa judgment directed the KPTCL to redo those seniority in view of Narayan judgment, my lord, which they did not do, my lord. And the source of entry into the service, never came to know, my lord. More than 5,000 engineers are there, my lord. We have annexed all those things, my lord. So the Supreme Court, the learned single judge, my lord, relying upon Ajay Kumar Shukla of the Supreme Court judgment, my lord, has dealt in a very detailed manner about this delay and latches, my lord.
My lords, one submission I would like to bring to my lords' notice, my lords. The petition filed by the respondents, my lords, before the learned single judge, the prayer itself, my lords, is infructuous because, my lords, there were 3 seniority lists published from 2000, my lords, 4 seniority lists published, and they were aware of it. That was a public notification, it was gazetted. None of those seniority lists from 2000, my lords, have not been challenged or are subject matter of challenge. Without, my lord, setting aside those seniority lists, this order could not have been passed, is my respectful submission, my lords. And Ajay Kumar Shukla also, my lords, with great respect, my lords, there was a challenge made to the seniority list in that case. The prayer itself challenging the seniority list is not there.
Which is Ajay Kumar Shukla, 1994.
No, my lord.
My lords,
That's 2021 SEC online that the learned single judge has extracted. The judgment, my lords, actually extracts only the judgments of these cited by the parties. Right? Your lordship should see para 21 is extracted at internal page 51 of the judgment, my lord, learned single judge's order. Ajay Kumar Shukla's case.
Now let us see that delay aspect.
Lords, that is considered from para 19. Lords, I am holding, my lords, writ appeal 427 of 23. Internal page 19, it would be, my lord.
427.
427 of 20.
Judgment will say.
Judgment internal page 48, my lords. Internal page 48, para 19.
Para 19.
From there, delay aspect is considered. It starts with, though I have arrived at a conclusion, the para starts with that.
Para 19.
19, para 19, internal page 48 of the judgment.
Yes.
Yes, ma'am. It starts with, though I have arrived at a conclusion that the petitioners have made out a case for interference in the impugned endorsement dated 5/3/2020. However, it is the principal submission of all the counsel representing the respondents that the writ petition deserves to be dismissed on the ground of delay and laches, as the petitioners have not approached this court at the earlier point of time, and the belated claim made by the petitioners is required to be rejected. I have also noticed various judgments referred to by Shri so-and-so learned counsel appearing for the respondent corporation with regard to delay and laches. It is well settled principle in law that right to promotion is not a fundamental right. Our right for promotion of the aggrieved parties have to be appreciated by looking into statutory provisions of the claim made by the aggrieved parties, like petitioners in this petition, when there is a discrimination based on applying the principle arbitrarily without following the statutory provisions, inter alia, dehors the eligibility criteria of such applicants seeking promotion. In this regard, sum and substance of submission of the respondents is that promotion should not be disturbed after a long lapse of time when there is inordinate delay. It is essential that one who feels aggrieved by the seniority assigned to him should approach the court as early as possible, otherwise there would be administrative complications. It is argued by the learned counsel appearing for the respondents that writ court shall take into account the delay and laches on the part of petitioners in approaching the court, and if there is gross and unexplained delay, court shall refuse to grant relief in favor of such petitioners. In the backdrop of these detailed arguments on delay and laches, by the learned counsel appearing for respondent corporation and other contesting respondents, one cannot miss the fact that writ court is having a equitable jurisdiction under Article 226 of the Constitution. And even if the respondents raised plea of delay and laches on the part of the petitioners, this court is empowered to analyze the satisfactory explanation offered by the petitioners.
Here, what is the explanation?
That's that they are not aware. That's and please see the prayer in the writ.
They are not aware about what?
Earlier seniority list which has been in existence from 2000.
The case of retrospective seniority, my lord. The junior engineers, my lord, they even did not, my lord, come.
How could you can't be aware?
Please, my lord.
How could it happen that you are not aware?
Lord, because it was not published in the official website of the KPTCL, my lord. It was never published, my lord. We have answered that question, my lord.
My lord.
This is a case of retrospective seniority, my lord.
For 21
My lord,
years,
sir.
you are not aware.
Please come to the writ petition. Whatever is pleading should be there.
For 21 years, you are not
No,
aware.
my lord. In 2017, for the first time, my lord, they have issued this on the official website, my lord, and they in the seniority list they have made a separate column. my
You
lord.
never cared about the promotion. You're right.
See
For
the case
21
of retrospective seniority, my lord. The AE has been given seniority with retrospective date, my lord.
If that is the case, it is
Even
not the
before they
case of
born in the
retrospective.
cadre, my lord. Even before they born in the cadre of AE, my lord.
This published in 17 was retrospective.
Please, my
No,
lord.
no, it is not retrospective.
My lord,
No,
I-
Lord.
I-
Learned
I-
friend
my lord,
wants to
my
say
third will
now,
come, my lord.
from 2000, what seniority list, what was given, he was not aware how they were placed, given seniority. That he came to know only in 2017, only 3 writ petitioners.
Details of Lords, the details of Lords, when did they Lords, they completed the Lords, the minimum qualifying service. Or Lords, when
21
did they
years,
acquire Lords, the degree?
After passage of 21 years, a person becomes adult. And you don't know about the seniority.
They become
They
wiser.
have not given all
Lords,
those
after
details,
20.
Lords. They give the details only in the year 2017.
They
Prior to
could
that, Lords, we were
too
totally
long
unaware
ago.
of Lords, the.
Yes, you explain to the court, well and good. Otherwise, this is.
That's the only delay explained. That, my lords, if in 2000, if a seniority list is come and if I am one of the employees, if a person A is placed above me, I will normally do an enquiry when he has come into this. And the prayer, if your lordship sees in the petition, it is only to quashing of the endorsement.
You file your statement of objections.
We had, my lords, it's been filed. Statement
Yes.
of objections
In the-
were
in the-
filed by the corporation.
Main process.
Yes.
Yes,
It was
ma'am.
filed.
Where are they?
Lords, that's in.
No.
Lords,
Got
the statement of objections, my lords, filed by the respondents, private respondents in my writ petition, or the respondent number two, which is the concerned party, my lords, would get at, my lords, volume 3, in volume 3, my lords. 537, page 30, 537. It should be volume 2, 537, statement of objections. Volume 2, Kodappa. Volume 3, yeah. Volume 3. That's by the KPTCL, alva. KPTCL. KPTCL's statement of objections, your lordship should get at 537, probably in volume 3. I am referring to 427, volume 3.
You got the judgments
Alerts?
on the delay aspect.
The learned single judge holds that, my lords, by referring to that judgment,
Yeah,
says
yeah.
if there is a indiscriminate arbitrary exercise,
Any Supreme Court judgment you got?
my lords, we have a compilation.
Ajay Kumar Shukla, my lord, that has been quoted in the judgment, my lord.
Which one?
Ajay Kumar Shukla, my lord.
My lords, one is 86-4 SCC 5.
20, para 20 of the improvement.
That is where the learned single judge relies on. But my lords, in KR Mudgal and others, 86-4 SCC, my lord, the Honorable Supreme Court had said, 86-4 SCC 531, that promotions after a long lapse of time should not be disturbed.
86.
86, volume 4, SCC 531, my lords. For 531, Mudgal.
Then they are relying on these two judgments, which set down the principle. This.
There also, if your lordship sees,
P. Sudhakar Rao.
Sudhakar Rao, if your lordship sees Sudhakar
That
Rao,
is
my lords.
their trump card is P. Sudhakar Rao.
That, my lords,
And Guru Sripat judgment, relying upon my lord.
Guru
Narayan's
Sripat-
judgment.
Earlier, 94.
no, my lord. Sudhakar Rao judgment says there can't be a retrospective promotion. That is not the case here. We have not, promotions to us has never been given with retrospective effect.
Prospective seniority, my lord, not promotion.
Okay, seniority also, it has never been given. Lord, that's the crux of the issue. In 2000, my lords, that's why I said there are 3 circulars which need to be seen and understood.
Let us see.
One, my lords, the first one which came into existence on, my lords, 25/7/1986, which your lordships would get at page 178.
Papers. No, unfortunately, the papers are not here.
Please,
So
my
we'll,
lords,
we'll continue.
we have also,
Please, my lord.
Prima facie we have gathered. This is only loud thinking. Papers are not here. Volumes are not here somehow. So we
there are
can
about
fix,
4 volumes in each writ appeal. That's a problem.
fix up a date of your convenience.
Very
It
well.
can be, it can be 19th of July.
My lord, 18th, my lord.
18th,
Please, my lord.
18th. 18th.
Please, my lords.
And time below, your lordship will fix the time, lord. Although I'm not making any request, my lord, but
We can fix the date. We can fix our judgment, but not time. Time we'll take up on that day. Now it is started, we'll take up. We have,
it may be treated as a parted, my lord, or not.
I think
we are not running away.
Please.
Both of us are not running. This is also part. So in the meantime, if you have any judgments are there,
Judgments, my lords,
both
a
of- both
short
sides-
compilation we'll make and with the proposition and para numbers.
Ask your colleague to give.
Please,
Well,
yours.
judgments are already fixed on this, along with the citations.
Where are they? I say in some, it must be in some other volume.
Lords, it's
Indeed, my lord.
You give.
fixed on 3/10/2023 itself.
All.
Lords, I appear for the, some of the respondents, my lords, the synopsis and compilation, my lords, of the decisions.
Respondents.
On the proposition.
Your original respondent.
Lords, the petitioner, lords, writ
Original
petition.
petition. Yes.
We have filed the judgment copy, my lord, in writ appeal 414, my lord. 414. Compilation we have filed.
Sir, interim order extended.
Get the compilation. And for we appear in function. Please just see.
Citations ಕೊಡಲ್ವಾ?
There is an interim order, my lord, sir.
Interim order is there.
Yes, yes.
Stand over to 9.
No,
18th
no interim order is there, my lord. No interim order is there, my lord.
My lords, there is an interim order and undertaking.
There is no.
No interim order. Tell me the date.
Find out whether there is or not.
My lords,
No, my lord, there is no interim order, my lord.
WA 414, my lords, the first matter, there is an interim order, my lords, on the very first date of hearing. And my lords have been extending the interim order from time to time.
Please see the order dated 27/4/2023.
Please, my lord. There is no interim order. Order says, my lord, the Sri Krishna Learned Council appearing for the employer KPTCL submits upon instructions that the exercise contemplated as per the direction of the learned single judge would take about 2 months. Considering that the appellants have raised various contentions and parties are before the court, it would be appropriate to direct KPTCL not to publish any list pursuant to the direction of the learned single judge without orders of this court.
That is the interim order.
That
My
is
learned
interim.
friend says that's not an.
They said that 2 months. Where is this list?
Lords, that order is passed.
Our papers, give ours.
It's an order dated 27/4/2023.
No, give our papers, case papers. What of it? You give papers.
Your lordships would get even in this writ appeal, my lords, 427 or 23.
Let us see. Who has passed?
They
We have
assured the
passed?
court that
No,
it will
earlier.
take 2 months. So court said, don't publish without permission of the court. That is the order.
It's the interim order.
dated 27th.
27th of April 2023. Thereafter, it's been continued, my lords, if your lordship sees. The order sheet would depict which my learned friend has in his hands.
Only says, my lords, not to publish without the leave of the court.
That's exactly what we want. He had appeared, Sunil, the vacation bench. And after that, my lords, KPTCL itself filed writ appeals. At that point of time, my lords, KPTCL had not decided to file writ appeals, but subsequently they have also filed writ appeals, challenging the order of the learned single judge.
Who is for the KPTCL?
My lords, my
I
learned
appeal.
friend who is on video conference, they have filed the writ appeals also. He
Yes,
is
my
Mr.
lord.
Shirish Krishna.
At the request of learned counsel for the parties, 10th out to 18th of July. It could be noticed from order dated 27/4/23 passed by the coordinated bench that in the said order following is recorded. Then considering that considering that the appellants have raised various contentions and parties are before the court, it would be appropriate to direct the respondent dash KPTCL not to publish any list pursuant to the direction of learned single judge without orders from this court. Full stop. The aforesaid directions will continue to operate during the pendency of the.
Please.
Grateful.
Now, only one thing, these two judgments of that Sudhakar Rao and K. Narayan,
Please, my lord.
they address the merit of the controversy.
Yes, my lord. And our case is based on K. Narayan and
Merit,
Sudhakar Rao judgment.
merit of the criteria.
Please, my lord.
Yes.
Please, my lord. And Guru Sripa judgment followed, my lord, the K. Narayan judgment, my lord. Guru Sripa judgment of this honorable court passed by the division.
That
bench,
is
my lord.
dealing with, my lords, the impugned, lords, the order
We'll meet it, my lord, we'll explain.
passed in
to-
2000,
Very
1986.
Retrospective seniority cannot be given, my lord. And same issue, same facts, my lord.
So we will concentrate on the next occasion whether it was retrospective or not.
Please,
Please, my lord.
your lordships can consider
Please.
that.
Yes.
In fact, my lords, they implemented, my lords, those orders in the light of, my lords, Supreme Court order and as well as, my lords, this honorable court order from 2010. Lords.
We'll see on.
And Narayan judgment, my lord, from the same state, my lord. Only PWD department, my lord.
Now. That side is it. No, nothing.
Number 75. Anish Jose Anthony.
My lords, appear for the appellants, my lords.
So who is opposing you?
I'm
She
the
is,
respondent,
she is
ma'am.
party in person.
Yes, my lords.
The certificate is there. What is happening to auction?
My lords, auction, the learned single judge are granted,
What
it's
is
already auctioned,
Forget learned single judge.
already auctioned in law.
What is happening to auction?
My lords, auction has happened on 30/6/2022. Auction has happened on 30/6/2022.
It is over.
It is over, my lords.
So any bidder was successful?
Yes, my lord, it was confirmed. It has
Confirmed.
happened.
Confirm.
Yes, my lords.
Any stay is operating in this petition?
No, my lords. The stay was conditioned that my lords may kindly see in page number 17, my
We'll
lords.
see page.
Yes,
Unless you answer our queries, we will not see any page.
Stay was not operational.
Stay was not operational.
Stay was not operational.
Confirmation certificate is issued to the bidder who is successful.
My lords.
Any sales certificate is issued in favor of the bidder.
My lord, it is a gold ornaments that has been pledged. It has been confirmed.
In what circumstances this 14% paid 90% amount?
It's not paid.
That is what recorded by Lawrence Single.
My lord, that is a error in the face of record, my lord. That is not the correct fact.
Then let us. So she was also one of the bidder.
My lords. No.
He was given since the gold was.
She was a borrower.
He was given opportunity to meet with the.
No, my lords. She approached this honorable court on 9/2/2022.
9/2/22.
Seeking waiver of interest.
So she at that time she was ready to pay the principal.
No, my lords. On that day,
Then only he can seek waiver of interest.
She was not even ready to pay any amount. That is a fact. On 9/2/2022, the learned single judge has granted conditional stay that the order is reproduced in page number 17 of my writ appeal.
9/2/22 he came for waiver.
Waiver of the.
He had taken loan.
Yes, my lord.
From you.
Yes, my
by
lord.
pledging the gold.
Yes, my lord.
So what was the loan amount?
Loan amount, my lords, there are 3 accounts were there. That cumulative 3 accounts, it will come to around 28 lakhs.
28 lakhs.
Not the exact, my lords, around 28.
Auction was held when?
30/6/2022.
13/6/22. So she deposited some amount in auction?
No, on 4/4/2022.
4/4/2022.
She approached us and deposited the amount that is subject matter in writ appeal number 490 of 2020, writ appeal number 490, and released the pledged ornaments in that account. She had cleared the amount that is subject matter of 490, writ appeal 490, and cleared closed the account and released the gold articles pledged.
Pardon?
My lord, she had deposited 4,18,000 on 4/4/2022 in subject matter of writ appeal number 490.
What was that writ appeal?
My lord, all are of similar prayer. My lord, 3 accounts were there.
In related to one of the account.
One of the accounts, she they deposited the 4,18,000. She cleared the amount and she bid
4,18,000.
4,18,000.
And she cleared that loan.
And taken back the gold ornaments also. It is released.
Now the gold also.
Yes, my lord.
That part of the gold.
Yes, my lord.
That portion of the gold.
That account was closed. It was 4,18,000. She had returned, taken back the ornaments also.
Then?
My lords, the learned single judge order says that you have to deposit 35%, 25% within 35 days. That is 15/3/2022. And the learned single judge also made it clear that failing which not only interim order stand resigned, but the writ petition itself runs the risk of being rejected.
So that order was complied with 9/2/22.
Nothing, my lords. It was not complied.
My lord.
1 second, not complied with.
Not complied.
So no amount was paid.
No amount was paid, but we are not proceeded with the auction. Since the gold was not auctioned, on 4/4, one of the accounts she paid and it was cleared and taken back the gold. On the remaining petitions.
1 second, that's 4/4/22 order in writ appeal 1/490 of 22 is relatable to one of the account.
One of the account.
Now the order which was passed in the proceedings of this matter by a single judge.
Yes, ma'am.
During the proceeding of the appeal.
Yes,
is dated 9/2/22 relates to another account.
My lords, all the petitions, a common order has been passed.
Then you are saying that this account was over and the gold was given back.
Yes, my lords.
So what remained now?
My lords,
what remained to be paid by her?
It's not about payment, my lords. We auctioned on 30/6/2022 and realized around 24 lakhs.
Correct.
the learned single judge directed us to deposit the amount before the registry of this honorable court. We deposited the amount.
1 second, when auction was held on 13/6/22, one of the account was cleared.
Yes, my lord. Remaining 2 accounts, we auctioned it.
Correct. So
The amount has been ordered to be deposited before the registry of this honorable court by the learned single judge. Now, by way of the final order, learned single judge permitted her to withdraw that amount, return the auction or equal weight of the gold ornaments. In addition to that, ineffectively, the learned single judge waived off our right to claim the amount also.
there you are right. Two directions are not reconcilable.
My lords,
Two directions of learned single judge paid 32 are diametrically opposite. You are saying that.
my lords, once based on the contractual obligation,
We are saying in your favor.
my lords,
Where is the successful bidder? Is a party here?
no, my lords.
Why?
My lords, I think she has not made the part.
How can?
No, the action purchaser was made impleaded, my lord. He did not come before this court for twice, and they only admitted that he has melted the gold jewelry, my lord. And therefore, the honorable court said, when there is, it is in the teeth of the interim order, you have sold the property in spite of she paying the 90% of the deposit, 25% were asked to deposit, my lord. I had deposited 4,18,000 and 1,10,000 as the interest, my lord. Total 5,18,000 I had deposited, my lord.
No.
They have agreed that also, and my statement of account also I had produced before this honorable court, my lord. My lord, their system is, even if I pay 5,18,000, my lord, they won't take into account for all the 3, my lord. They say there was a common order passed for all the 3 loans, my lord. According to that, I was supposed to pay 5,60,000, my lord.
My lords,
But I had paid 5,18,000, my lord. But whatever I had deposited, they refunded back, my lord. Muthoot Finance refunded back and said we are not taking that into 3 accounts. I divided and paid it to the bank, all the 3 accounts, my lord, all the virtual accounts, but they refunded back and said we are not taking the 3 into 3 accounts. Only we are taking, there is a system that we have to take only into 1 account, my lord. And therefore, the honorable court rejected their plea that they have not taken for all the 3.
my lord, it's the first time it is all cleared.
And therefore, it is written here, my lord. I'll come to the order of this honorable court, my lord. I will bring to your honorable court, my lord, what is the matter was rejected, how it was rejected. It has been written here, my lord. My lord, at page 16, my lord, I have produced along with my application, my lord, the order of this honorable court in the writ petition, my lord. The submission of the learned counsel respondent financier was that there were 3 loan accounts of the petitioner. Therefore, the deposit amount of the petitioner pursuant to the order passed with the court was taken into other loan account, and the gold in the subject loan account was auctioned. This court could found fault with the said action of the financier, observing the action has taken place on 30/6/22, despite the petitioner depositing 90% of the amount, as was directed by this court. If 10% was remaining, the respondent could have approached the court for vacating the interim order, but could not have put the gold into action.
Where you are reading?
I'm
My lords,
reading at,
in page 11.
16 of my application, wherever
Page
I
is
have
page
produced.
11 of the
Page 11 of the
order.
order, my lord, final order.
Paragraph number 4.
Page 11. Internal page.
Internal page of the order, my lords. Paragraph number 4.
So that is his case. 90% of the amount was.
No, my
paid.
lords. No, my lords. It's absolutely false. What happened is that by 15/3/2022, with the last date which was given by the learned single judge for complying the order, it was not complied. On 4/4/2022, she came with 4,18,000 and deposited in one of the account, cleared the amount and taken back the gold. If that was the case, she will not receive the gold.
You are coming from outside?
No, my lord.
Come to day after tomorrow.
Yes, okay.
Day after tomorrow, we'll continue at 11.
Yes.
Grateful. My lords, I am passing over.
At 2:30, my lord.
And what learned single judge has done?
My lords, learned single judge has ordered the release of the amount which we had recovered from by auctioning the amount to her. In addition to that, equal weight of the gold ornaments which has been pledged by her, ineffectively waived off the loan also.
So what do you say about that? Either first direction will sustain or second direction will sustain.
No, my lords, both will not sustain because I respectfully, I will submit, my lords. Why? Because
Both sustains, my lord. There was a
My
common
lords,
order
why?
against
Because
all the three loan action notices, my lord, in spite of the stay, in
My-
spite of the pending of the petition before this honorable court. And though they know that they had given 50% loan against 100% security, they have sold the property.
We'll go through this.
They have melted the property. And also I was entitled for 60 lakhs, my lord, because that property is 60 lakhs. They have sold it for 23 lakhs. The honorable court called for the records and found out how 618 grams can be sold for 23 lakhs.
that is the case,
When
it
the-
has to
one
be
minute, one
adjudicated,
minute,
my
sir.
lords,
One
for the
minute.
competent civil court or arbitrator, my
Please,
lords.
please. 1 gram is 6,600, my lord. 618 comes itself as 42 lakhs. And then for the making, etc., will come to 60 lakhs. Other precious stones will come to 30 lakhs. They had taken diamond, there was precious stones, my lord. With all that, I have got the list of all the documents along with the purchases wherever I have purchased, my lord. In all renowned jeweler only I had purchased. And it was with my father-in-law and my
Madam,
mother-in-law.
how could be that you get the money deposited back and also get the release of gold?
Yes, my lord.
Both
That is
cannot-
true. No, my lord.
Both cannot go together.
No, my lord, the amount itself is 90 lakhs. If that is what they have deposited 24 lakhs. And my amount is 60 lakhs jewels. So both come to 84 lakhs. They have to give my jewels. They had agreed, my lord. In fact, they had agreed to give the jewels. There was a.
My lords, during the pendency of
Gives the loan, my lord. If I give 100 grams, out of 100 grams, it gives loan for 50%, my lord, not 100%. 100 grams only, they would remove the all unnatural stones, natural stones, and the wastage, etc., my lord. They will remove 30%. Now, out of 100 grams, it will come to 70 grams, my lord. Out of 70 grams, he gives loan for 35 grams, my lord. That is 35 grams, my lord. And when I have pledged so much, they have given 15 lakhs. One is 4 lakh 65, another is 4 lakh 5,000. Yes, they have got.
my lords, I am
They have
passing out.
got the loan because my jewelry had lot of diamonds and this one, my
My
lord.
lords,
I don't give
I
loan
am
for
passing out
diamond.
2 judgments also.
I have given the judgments to you, my lord. I have given the list of authorities. I have filed, my lord. I have filed the judgment. It is nothing but criminal breach of trust, my lord. With lot of trust, they only called me, my lord. They said, doctor, you take loan even for your house construction, they said, my lord. And they offered me 0.87%, my lord. But when all that was done, when I was a high customer of taking 25 lakhs for my house construction, where my daughter is physically disabled, my lord, for that to roam about, I will not have time, my lord. I will not have this one. That is why, my lord, these people have cheated me in that, my lord.
Grateful, my lords.
Day after 2:30, I'll come.
List number 2. Rate appeal matter.
List number 1, my lord, serial number 20. It's number 1, serial number 20. Serial number 20, my lords. List number 1. Could it be taken up on Friday, my lords? Because another connected writ appeal is there.
Number 2, serial number 1.
Well, let's.
Time for respondent number 4 in this matter.
Well, that's one. The doctrine of pleasure, my lordship had posted today. Leave for clarification. Please. It's clarification. That's all. Wait.
My lord, the writ appeal 210 of 2023. My lord, other councils are not there. There's a batch.
No, my lords, petitioner council, appellant council is there, my lords. I've informed them. We've informed the,
No batch matters.
no, my lords, in ours was only segregated today only for. Sorry.
By mistake.
Sorry.
My lord, scheduled caste and scheduled tribe. My lord, amendment act. My lord, none of the appellants councils are there. No.
Serial number 10.
Serial number 10.
ಅದೇ ಹೇಳ್ಬೇಕು. ಅದೇ ಎಲ್ಲ ನಾನು ನೋಡ್ತಾ ಇಲ್ಲ. ಅದು ಹೇಳಿದ್ರೆ ಆಗತ್ತೆ. ಅದೇ ನಾನು ಹೇಳೋಣ ಅಂತ ನೋಡ್ತಾ ಇಲ್ಲ. ಇದೇ ತಾನೇ 27473 of 23. My lord. July, ಅದು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ. And the last was on 21st of January 2024. ಆಮೇಲೆ ಇಂದ ಬಂತು. ಇದು ತೋರಿಸ್ತಾ ಇಲ್ಲ. Yeah, yes. My lord, may I make one? No, before, my lord, before. This amendment is on 27 July 2023. My lord, can I make one submission? My lord, can I make one submission? My lord, this Act 30 of 23 is challenged before the learned single judge, my lord, in two writ petitions. My lord, my submission to my lord is that, my lord, the appellants have come in before my lords aggrieved against the orders of the authorities. Admittedly, they have not challenged this act before my lords. My lord, if they can be given the liberty, my lord, of approaching the learned single judge, because obviously they'll have to challenge this act, my lord, if they have to, my lord, sustain the order or otherwise, however, whatever their case might be. My lord, if that liberty is given to them, they can go before the learned single judge. My lord, once for all, there'll be a quietus to this entire litigation.
Tomorrow is posted minute before the next.
Section 5 is a retrospective effect.
Yes. Tomorrow it's.
My lord, all that is being considered, my lord, by the learned single judge is what I was informed. And some of the writ appeals have been withdrawn, and my lord, additional grounds have been raised.
Even then it's.
Very
Then you are also.
Yes.
Matter listed, just before the student going there.
Tomorrow.
Next week or something. Yes.
No, tomorrow it is. Tomorrow it
Probably
is.
it's Friday.
Yes.
That is what I just, when I learned, I thought because listed before single judge this Friday. They have
That's
to
why
come.
that's why these matters are being adjourned.
That's why I thought I'll.
Yes.
Kiran, they can withdraw this appeal and go.
Let
Very-
us await, Manoj. In fact, after 3 weeks or 4 weeks, your lordship may have it.
Yeah.
Please, Manoj. Please. No,
Yes.
that's the whole thing. Unless that, as the lordship says, in view of the amendment, Manoj, they may not have much to argue unless. It would be just, Manoj, because.
Obliged.
The interim order may be. Wherever their interim orders may be.
Thanks, Kiran. Thank you. Kiran, once even that is there, so then again they'll have to amend the writ appeals here. Chapter 748.
Serial number 1, serial number 21.
Even this matter with regard to the generator.
My lord, my lord, my lord. My lord, my lord,
Submission, my lord.
my lord.
Serial number 20.
20.
That's similar matter. Common order passed by learned single judge. 9:47, my lords have given a date as Friday, my lords, requesting that serial number 20 could be taken.
Friday.
Friday. Please.
Number 2, my lords. Serial number 2, also the similar matter. It is under serial number 10 of the writ appeal. Serial number 2, it's appeal number 879 of 23. At serial number 2 in the second day, the same under same subject, under the writ appeals under serial number 10.
Oh, 30th July.
28.
Number 21.
I appear for the petition.
That review petition.
Review.
Just refresh.
Yes.
Okay. It was argued in fact. Yes. So which is the order in the review? Page?
Page lot 21, annexure 9. Page 21, in WP 51325 and 51326 of
12th June? No.
22nd January 2016. Page number 21 of the review.
Correct.
Background of the case is this, not? The respondent was granted quarry lease in the year 2011 for extraction of building stone in survey number 16 of Pullasandra village. The same was cancelled by the competent authority on the ground that survey number 16 is situated within minor forest area.
No, forest.
Forest. Notified minor forest.
Notified.
Yes, it was notified in the year 1936. That order was under challenge in this writ petition law. Last may kindly peruse para 3, page number 23, internal page number 3. So and so learned additional government advocate strenuously argues that unless clearance from the central government is obtained, there could not be any non-forest activities in the forest area. Then, my lord, we accept the contention of so-and-so that in forest area, no non-forest activities could be undertaken without the consent of the central government. Nevertheless, the question involved in this case is whether the area concerned is forest land or not. Then, Lord, page number 11, page number 25, para 11, please. Before that, page number, para 10. So-and-so strenuously argues that the area is a minor forest area, and therefore no non-forest activities could be conducted without the concurrence of the central government. Then, in his endeavor to make home his point, he relies upon the notification dated March 4th, 1936, issued by the government of princely state of Mysore in exercise of powers under section 35 of Mysore Forest Regulation. This was produced, Lord, during the course of argument. Thereafter, the coordinate bench of this honorable court observed, before we advert the said notification dated March 4th, 1936, we refer the provisions, etc., etc. This very notification was not adverted to in the entire order law.
Pardon?
This notification, the very opening sentence of para 12, para 12, page number 25.
Before we advert to the said.
Before we advert the said notification dated March 4th, 1936, we refer so and so. Thereafter, this notification was not adverted into
By learned single.
by the coordinate bench. That is an error apparent on the face of the record. Though we have placed that notification on record, clearly indicating that this survey number 16 is a minor forest, and the quarry was granted within the notified minor forest.
Where is that notification?
Lord, I have produced one more notification along with the additional document also. The last may kindly take. I have filed on 23rd February 2022.
So I8 is produced.
Though this was a part of record law, during the course of argument, it was produced along, filed on 22nd February 2022.
Where is
Document number 1. Page number 6, not?
(23 to)
23 to 2022. Page number 6 is the notification. Document number 1.
60, page 6.
Page 6. It is dated 4th March 1936. Page number 6, document number 1.
This is that.
Yeah.
Which is that entry?
The first one. May I read. The Government of Highness, the Maharaj of Mysore, pleased to declare under the provisions of section 35 of Mysore Forest Regulation 1900 that the land limits of which are described in the schedule annexed hereto shall be constituted minor forest under the name of Korategere Betta Minor Forest Block in the Magadi and Tumkur taluks for the purpose of rules for management of minor forest issued with the government notification, so and so. Now, under that, Tumkur Gulur village, under that village, Pullasandra. Kindly notice Pullasandra under village column. Gomal 16 assessed waste next to
Pulasandra.
So
this is that.
Yes, ma'am. This is the very area.
This is the subject.
Yes, please. Pullasandra Gomal 16. Total extent is 85 acres, 16 gunta.
This block is situated at a distance of 6 miles north.
That is the boundary.
Kudu boundary. So it is part of
Korategere Betta block.
It is Kotarande Betta Minor Forest Block.
Yes.
What is it?
Korategere Betta, the name of that hill.
Name of?
That hill, that forest. Yes.
That's all.
This is one of the error apparent on the face of record.
In the act itself, there is no minor forest.
No, I'll point out. One more.
My lord wanted me to ask him.
I thought you completed. Yes.
Please. One more aspect of the matter, will ask me kindly go to para 19, page 27. Para 19, page 27.
Same.
In the same judgment, impugned judgment.
Para 19.
19. Before that, para 18, please. We repeatedly requested the state to produce any document to show that this area was even included in the forest area. There is no material on record to show that it is part of forest area. This is contrary to what has been recorded in para 11.
Contrary to?
Para 11, because we have produced
contrary to notification.
Notification. Though
it was produced.
It was produced, it is noted in para 11. Para 11, it is noted. Then para 19.
Yes.
So and so further draws our attention to an unreported decision of this court in the case of the division railway manager and others versus the state of Karnataka and others in writ petition, so and so. In the said decision, the state government wanted to prohibit railway authorities from using the portion of the said survey number for non-forest purpose. It was alleged that the railway authorities unauthorizedly established a goods terminal and wanted to lay down railway track illegally. The Honorable Single Judge held that the land covered by the said survey number was not a forest area as it was never declared as a forest area. The decision of the Honorable Single Judge was affirmed by the division bench by the judgment and order dated January 7, 2010 in writ appeal number so and so. We are informed that an application for review of such order was proved abortive. Ultimately, the Supreme Court of India dismissed the special leave petition under Article 136 of the Constitution of India. We thus got a judicial pronouncement in relation to this head survey number 16 that was never declared as a forest area. This is wrong because, Lord, the judgment which was relayed was in respect of survey number 1 of Kadugodi plantation in Bangalore. It is nothing to do with
Which judge?
this judgment referred to in para 19.
Page 19 wala.
Para 19. Page 27, para 19.
That was also declared a minor forest.
No,
And I'll point out. Sure.
Para 19, the judgment referred.
Learned bench says that we thus got a judicial pronouncement in relation to the service surrender.
In relation to survey number 16. Survey number 16 is Koratigere Betta.
Then you relied yourself this judgment.
That is misplaced. Misplaced, but in this judgment, this judgment was rendered in respect of Kadugodi, survey number 1 of Kadugodi. Kadugodi is in Bangalore. It is nothing to do with survey number 16 of Koratigere Betta, which is Pullasandra, which is in Tumkur. This I have reduced before this. Therefore, relying on that judgment, presuming that that judgment was rendered in respect of survey number 16 is erroneous. Now, so far as the contention that there was no concept of minor forest and all that, Lord, it is on merits. In the review petition, my endeavor is to show it to the Honorable Court that the error apparent on the face of record, these are the prima facie errors in the impugnment.
We got judgment that Kamlesh versus 2000.
I'll reduce.
Everything is discussed about review.
Please.
Find out and give.
Please.
Kamlesh versus Mayawati. Kamlesh versus Mayawati.
I shall.
Yes.
Lord, that 1900 Act, if your lordship's take, my lord, we have given it also. There's nothing like a minor forest.
Before my learned friend.
I think, you have said enough. Let me complete it.
No,
He has
before
asked me,
if
you
it
know,
is
keep on,
touching the merits of the case, Lord,
Not fair.
I may be permitted to submit. If it is touching the merits of the matter, I may be permitted to submit my submission.
Okay. Yes. My lord, please take, my lord, the Forest Act, Mysore Forest Act of 1900. There are only 3 types of forests under the said act. Please take, my lord, the definition, clause 2. section 2, subsection 11 to 13. State forest, village forest, district forest. There is nothing like, my lord, a minor forest. Now, please look at, my lord, that notification. My lords may come to, my lord, in the petition itself. They have produced, my lord, page 36 of the review petition. Page 36 of the review petition. There is, my lord, a notification issued by the government with regard to the management of the minor forest. Sorry.
Page
36, my lord.
of
Petition copy, my lord.
review.
The review petition.
That is in Kannada.
My lord, English is there, my lord. It is in English, my lord.
Yes. We'll continue tomorrow. At what time?
Subject to your lordship's convenience, but I should be here, my lord, whenever your lordship call me, my lord.
Immediately upon commencement, because one matter is kept at 11. So before that, we'll finish this.
Yes.
That lady.
Yes.
Private party.
Can it be or 2:30, my lord? If it's not inconvenient, my lords, 2:30?
2:30.
Please, grateful, my lord.
Tomorrow, 2:30, there is a bench.
Oh.
So, anytime you come, we'll take.
Very well, very well. I'm grateful to you.
Whenever
Lordship.
you come, we'll take.
Please, sir.
Lords, may we seek indulgence, Lords?
That's okay, that's okay.
Yeah, okay, sure.
Right.
Yeah, I'm okay.
Serial number 22. The notice received, accused number 1 has not been issued. If direction can be passed to issue notice to
I undertake to,
accused number 1.
I undertake to file wakalat for accused number 1.
Number 22. Learned advocate.
Saravana is.
What is your name?
Saravana is.
Appears and states before the court that he will file wakalatnama on behalf of his firm.
Lords, may we
Send over to 6th of July, 6th of August, in order to enable learned advocate to file wakalat.
Business.
Lords, may we seek indulgence of the court, Lords, that the nomination matter, the university, could your Lords kindly consider giving some time, Lords? There's some urgency. The entire working of the university has come to us.
Their appointment was for 3 years.
Yes,
When that 3 years expired.
it's 16th of last month, June.
I am sorry. It's not so. Appointment order
We'll
does not.
go
say
to the court.
No, no.
Lords, your lordships can hear the matter.
Term of the syndicate is over.
Lords, it's not over according to us. Their own memo, my lord, they have filed about 150 pages. University is now more interested. The nomination is by the government.
The university's functioning has come to a stand. I'll show, my lords, section 31 is the only section which requires to be read.
That is the crux
In
of the
terms
issue.
of that, my lords,
36 of.
30, yes, under which
Serial number 28.
28. Pass it to. Lords, we have the extract of both the provisions and the term.
Lords, that itself is the issue. That is the issue on hand. Well, can't keep putting this.
How much time it is likely to take?
Lords, it will take at least My lords, on main itself, my lords, it should not take more than half an hour.
No, let's 5 minutes. I'll just show two provisions, my lords. If the term has come to an end, it becomes academic.
After tomorrow we'll try.
Lords,
Please.
lords,
My lords, one humble submission.
Please.
no, we may be given liberty to mention to your lordships, my lords, on day after tomorrow.
Friday, my lords.
If it is down below
before-
in the list.
After 2:30, my lords, they have the matters before that. SC/ST validity matters are there. But before that, I'll be here. Only after 2:30, my lords, the learned single judge has
In
posted.
fact, your lordship, please to observe the
That
other
ma-
matter.
That, my lords, I am there in that. That probably, but I'll be here, my lord, day after.
Will not bother you after two.
My lords, one humble submission, my lords. I appear for petitioner in 28.1, my lords.
That's all.
My lords,
Friday, my lords.
Friday, in the
Lord.
first, in the first.
Please.
my lords, one humble submission. I appear for petitioner in 28.1, my lords. There is office objection why other petitioner are not made as a party. There is office objection with respect to why other petitioners are not made as a party. I sought, I mean, I have not sought any relief against them, so I have not made as a party. Kindly, office objection may be overruled. In the same matter, 28.1.
That they will.
Serial number 24, my lord, that goes with the management serial number 48 and 49, my lord. They are at serial number 24, 25 and 10, 26. Today it is listed, my lord. May I request your lordship kindly pass a judicial order in connecting those petitions.
Serial number 49 and 50, my lords, along with the 24. My lords, there is a big urgency in the matter because the students are not allowed to attend the classes. Petitioners are not allowed. That's the reason, my lords, today, my lords have fixed a date. It may be, my lords, because the exams also fast approaching.
We'll see.
The serial number 58
Date will be given, my lords, kindly, my lords.
Tomorrow in the second.